Spanish interpreter is here. Can you hear me?
I can, and we are videoing from 1 to BRC2, so the defendant is in 2, and they're putting the headphones on her as we speak. So, have you been sworn in today?
Yes, Your Honor.
Okay, and you could just announce your name for the record.
Ale Figueroa, State Certified Spanish Code Interpreter.
Okay.
And the defendant can hear me in BRC2, Your Honor.
Okay, perfect. And I believe we have, you saying we have a witness here? Do they need the Spanish interpreter too?
Yes, ma'am.
Okay. So we also have a witness present who also needs the interpreter as well. So logistically, I think that yesterday the defendant was able to hear on the headphones, and you were also, and the interpreter was also over the loudspeaker in courtroom 1.
Yes, Your Honor. The defendant can hear me through the headphones in courtroom 2.
Okay, but we'll also need you to interpret as well verbally at the same time in 1 because of the victim.
Okay. For the victim, then I'll do consecutive, Your Honor.
Okay. All right. Good morning. Ma'am, can you please tell me your name?
Yoreli Solorzano. Yoreli Solorzano.
Yoreli Solorzano.
All right, ma'am, you're charged in 2020 MM 301AA with battery domestic violence.
Yes.
Okay, and I'll need you to, and I need the victim to be able to understand what's happening as well.
Oh, I'm sorry, Your Honor. The victim is for this case.
Yes.
I'm sorry. That was my confusion. I heard that you had a victim. I wasn't aware that it was for this case. I apologize.
Okay. So is there a way for you to translate over, as I stated yesterday, the interpreter was able to translate over the loudspeaker so that...
Yes, Your Honor.
Okay.
Bien, señora Solorzano, se la acusa en el caso 2020 MM30188 de violencia doméstica, agresión física.
All right, I do find probable cause for the offense, and I will appoint the public defender to represent you.
Determino que existe indicio de criminalidad y se le designará defensor público para que la represente.
And we do have a witness present. Sir, can you please raise your right hand to be sworn in?
Tenemos acá un testigo. Señor, por favor, levante la mano derecha.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad, solo la verdad y nada más que la verdad?
Lo juro.
I do.
All right, please place your hand down now.
Baja la mano.
All right. Can you tell me your name and spell your last name, please?
Me dice su nombre, por favor, y me deletrea su apellido.
Marcos Maza, M-A-Z-A.
Marcos Maza, M-A-Z-A.
All right, Mr. Maza, how do you know Miss Solorzano?
Señor Maza, ¿de dónde conoce a la señora Solorzano?
New York.
From New York.
Are you in a relationship with her?
¿Está en una relación?
Sí,
Yes.
Do you live together?
¿Viven juntos?
sí.
Yes.
Are you afraid of her?
¿Siente temor de ella?
No.
No.
Do you want to have continued contact with her through the pending of this case?
¿Desea tener contacto con ella mientras este caso está vigente?
Sí.
Yes.
Has there been any violence in your relationship in the past?
¿Ha habido algún indicio de violencia en la relación antes de esto?
Pequeñas discusiones.
Little arguments.
Okay, anything physical?
Algo físico.
Normal. Movimientos de mano. Sí. Nada del otro mundo. No, nada grave.
Normal, just hand gestures, nothing out of this world.
Okay, and if something like this were to happen again or you felt threatened, would you call law enforcement?
Si algo como esto vuelve a ocurrir o si usted se siente amenazado, ¿llamaría a la policía?
Sí.
Yes.
Okay. Ms. Fusco, did you have any additional questions for
Nothing
witness?
further, Your Honor.
Okay, and Ms. Custon?
Yes, if you were to, if Miss Solorzano were to be released without paying any money for bond, would you feel comfortable with that?
Una pregunta más de parte de la licenciada. Si la señora Solorzano pudiese salir de la cárcel sin tener que pagar fianza, ¿estaría usted de acuerdo con eso?
Sí.
Yes.
Do you think she'd come to her court dates without having mandatory reporting?
¿Usted cree que ella vendría a la fecha de comparecencia en la corte sin tener que reportarse obligatoriamente?
Sí.
Yes.
No further questions.
No tengo más preguntas.
Okay, all right. So, Ms. Solorzano, I am going to allow you to have contact with Mr. Maza.
Bien, señora Solorzano, le permitiré el contacto con el señor Maza.
It's going to be non-hostile and non-violent contact.
Contacto sin hostilidad y sin violencia.
So that means no grabbing at him inappropriately, no scratching him, no kicking him or punching him.
Así que nada de agarrarlo inapropiadamente, ni de rajuñarlo, ni de patearlo, ni de golpearlo.
You may not get in his face or be disrespectful to him
No se le puede encarar ni faltarle al respeto
or raise your voice at him.
o alzarle la voz.
Do you understand those conditions?
¿Entiende las condiciones?
Sí.
Yes.
You're not to possess any weapons or firearms or any ammunition.
Se le permite la tenencia de ningún tipo de arma ni de municiones.
And they're just phoning in, correct, Courtney?
Yes.
Okay, they're just phoning in, Ms. Custon, so I am going to place her in pretrial release. It's a phone in, it's not reporting in person.
Your Honor, the reason we request ROR instead of PTR is because it does cost money.
Okay.
It's minor, but it does cost.
Okay, well, let me let him translate what I said.
I'm sorry.
That's okay.
Yes.
Bien, y creo que voy a emitirle la libertad provisional porque no tiene que ir y reportarse en persona, lo puede hacer telefónicamente. Eso, señoría, la razón por la que pedí la libertad bajo palabra es porque eso cuesta. No es mucha la cantidad, pero sí cuesta.
Okay, and so your argument is based on financial?
Yes, Your Honor. I think it's $17.
Okay, all right.
Your Honor, the state asked for PTR rather than ROR.
Okay, she has zero criminal, I'm sorry, Mr. Interpreter, you can interpret.
Not a problem, Your Honor. Entonces, su argumento es basado solamente en el aspecto financiero. Sí, la Fiscalía desea pedir que se emita la libertad provisional en vez de la libertad bajo palabra, su señoría.
All right, based on the witness's testimony, as well as my review of the facts and her lack of any criminal history whatsoever,
Bien, basado en el testimonio del testigo, basado en los hechos del caso y en el hecho que ella no tiene antecedentes ninguno,
I think in the interest of justice, releasing her on her own recognizance is fine with me.
creo que si vamos a ser justos, dejar la libertad bajo palabra me parece bien.
The state's objection is noted for the record.
Se hará constar la objeción de la Fiscalía.
All right, thank you, ma'am. Thank you, sir,
Gra-
for your testimony.
Gracias, señor, y gracias, señor, por su testimonio.
Una pregunta.
I have a question.
Yes.
¿Ella saldrá ahora mismo?
Will she getting out right now?
They will process her and she will be released. Courtney, do you know how long that takes?
It can be later on today.
Do you have a phone number for him?
He can call the 407-836-3400 for general information.
There's a phone number that you can call. What did you say?
836-3400.
Bien, señor, a ella la van a procesar hoy. Puede que no salga sino hasta más tarde, pero hay un número de teléfono al que puede llamar para pedir información. Es el 407-836-3400.
I can write it down on a piece of paper. Taylor, can you grab this for me? Is there a little door thing? I think.
Le van a dar el número de teléfono en una nota.
You can call that phone number, sir, and they'll tell you when she's ready to get picked up, okay?
Puede llamar a ese número y le dirán cuando ella esté lista para ser recogida.
¿Tienen servicio de español?
Do they have service in Spanish?
I don't know, sir.
No sé, señor.
They do. Okay.
Sí.
Okay, thank you. All right, and Mr. Interpreter, we only had one Spanish interpreter case, but can you just make an announcement in the gallery if anybody needs the Spanish interpreter to raise their right hand?
Sure thing, Your Honor. A las personas que están en el público para testificar, ¿alguien necesita el intérprete de español? Levanta la mano.
All right, I don't see any hands raised out there. Thank you so much.
Not a problem, Your Honor.
Good morning, this is Judge Wish. Is this the Portuguese interpreter?
Yes.
Yes, Judge Wizard. And yes, my name is Ludovina. My ID number is 207732. And I will be your Portuguese interpreter today. But, Judge, with your honor, if it's possible to ask if this is for Brazilian Portuguese, European Portuguese, or Cape Verdean, so that you have the right interpreter?
Well, if you could introduce yourself to the defendant, he has headphones on, and see if he understands you. I have no idea.
Thank you. Sim, bom dia, vou ser a intérprete da ligação. Se fala português do Brasil, ou português de Portugal, ou de Cabo Verde?
Can you hear over the loudspeaker? Because I don't think they're coming through on the... Can you all hear over in the other
Yes, Your Honor.
courtroom? Okay. Could you repeat yourself, Madam Interpreter? I'm sorry. He could not... He had headphones on.
Absolutely, Your Honor. Se é para português do Brasil, português de Portugal ou de Cabo Verde?
Understand this? Where talk? Portuguese. Portuguese. It's not Portuguese. Just not Portuguese.
Your Honor, it's saying it's not Portuguese, and yes, I'm speaking Portuguese. That's why I'm asking if it's for European Portuguese or Brazilian. So this is Brazilian. So he's just saying this is not Portuguese, but I speak Portuguese. But I'll be happy to bring a Brazilian Portuguese interpreter to the court.
That would be
you all be so kind to hold?
Okay, thank you.
Excellent.
Okay.
Thank you so much for using your services.
Thank
Please
you.
hold for your Brazilian
Okay.
Portuguese interpreter. Thank you. Please hold.
Thank you.
I am so sorry. Please hold again. I'm going to try it again.
Okay.
Thank you for your patience.
Thank you.
hold for the next available interpreter.
Thank you for calling Language Line Solutions. This is Annabella, ID 246048. I'll be your Brazilian Portuguese interpreter today. Is your customer with you, or you need me to call them for you?
No, this is Judge Wish. It's very difficult to hear you. I don't know if you could get closer to your headset or speak a little bit louder.
Yes, I can speak louder.
That works. Thank you. Okay, and have you been sworn in today?
Not yet, Your Honor.
Okay. Do you swear to translate from English to Portuguese, Brazilian Portuguese, from Brazilian Portuguese to English to the best of your ability?
Yes, I do.
Okay. And could you introduce yourself to the defendant? He is in another courtroom, but he can hear you. I just want to make sure he understands you.
Bom dia, senhor. Eu serei a sua intérprete nessa ligação.
Ok. Obrigado.
Nada.
Okay. Good morning, sir. Can you please tell me your name?
José Ricardo.
Senhor, bom dia. Qual...
All right. Can you let him know that he needs to wait for you to translate? If he wants to use an interpreter, he cannot speak in over you.
Senhor, se o senhor quiser utilizar uma intérprete, o senhor tem que aguardar pela interpretação da intérprete.
Okay. All right, sir, please tell me your name again for the record.
Seu nome, por gentileza.
José Ricardo Paulino da Silva.
Senhor José Ricardo, qual o sobrenome?
Da Silva, Paulino da Silva.
José Ricardo Paulino da Silva.
All right, sir, you are here in case number 2020 CF 7691.
O senhor está aqui por causa do caso 2020-CF7691.
You were arrested pursuant to a warrant in which probable cause was previously found.
Senhor, o senhor foi preso por causa provável.
For 4 counts of lewd and lascivious molestation.
4 acusações de molestação.
And 4 counts of lewd and lascivious conduct.
E 4 acusações de conduta inapropriada.
I'm going to appoint the Public Defender's Office to represent you in your case.
Eu vou indicar defensor público para representá-lo.
Counts 1 through 4 are life felonies.
Da acusação da 1 a 4 são para encarceragem da vida toda.
And counts 5 through 8 are second degree felonies.
E de 6 a 8 são crimes de segundo grau.
Ms. Fusco, does the state wish to be heard as to bond on counts 1 through 4?
Yes, Your Honor. The state asked the...
Let her interpret. We have
I'm sorry.
to not talk over each other. Okay.
O Estado quer solicitar uma fiança.
The state asked the court to consider all the facts in the arrest affidavit.
O Estado quer considerar todos os affidavits.
To find proof evident or presumption great.
Would you repeat the sentence, ma'am, please?
To find proof evident or presumption great.
Para ter alguma evidência de prova.
And hold the defendant without bond.
E manter o réu sem fiança.
The arrest affidavit also says
O depoimento também diz
The defendant was out on bond in another case.
o réu estava fora, sob fiança, num outro caso.
At the time of this arrest,
No momento dessa prisão,
the Orange County Sheriff's Office Record Department has found an OPD case.
o condado de Orange achou um caso de OPD.
We are trying to locate that case and ask the court to revoke the bond in that case.
Nós estamos tentando localizar esse caso e revogar a fiança nesse caso.
Ms. Tustin, do you have any argument?
Yes, Your Honor. The only evidence that links my client to the alleged incidents is state.
Let her, like,
Oh.
little piecemeal, please.
A juíza perguntou se ela tem algum argumento, ela diz que sim. A única evidência relacionada ao meu cliente
Are alleged victim statements.
é o depoimento da vítima.
There's no confession from the defendant.
Não teve nenhuma confissão por parte do réu
And no independent witnesses.
e nenhuma testemunha independente.
As for revoking the bond,
Em relação a revogar a fiança,
this case was a warrant.
esse caso era uma pedido de prisão.
So we ask if the date of this offense
Nós pedimos então que na data dessa ofensa
was after or the same
foi depois ou no mesmo dia
as the previous case,
do caso anterior.
the bond not be revoked.
Então a fiança não deve ser revogada.
Okay, I looked up in Odyssey, I do see the other case.
Eu vi o outro caso.
I did see him at that initial appearance.
Eu vi ele no comparecimento inicial.
That is case number 2019 CF 17189.
Esse é o caso 2019 CF 17189.
The public defender does represent him in that case.
Ele foi representado por defensor público.
He was seen at initial appearance on December 21st, 2019.
A primeiro comparecimento foi no dia 21 de dezembro de 2019.
The date of the offense alleged in the new case.
A data dessa ofensa no novo caso
the warrant says one specific date of November 1st, 2019.
O mandato diz que a data foi 1º de novembro de 2019.
But within the warrant, the allegations are that the incidents occurred on over 20 occasions.
Porém, no mandado, tem alegações de que esse incidente ocorreu 20 vezes.
One of which is around October 2019.
Uma dessas ocorrências foi em outubro de 2019.
I'm not sure if there are any dates after that specific incident.
Não tenho certeza se tem alguma data depois desse incidente especificamente.
Looks like this was over a longer period of time.
Parece que isso acontece há um período durante há já algum tempo.
Ms. Fusco, can you show me anywhere in the affidavit that any incident occurred after 12/21/2019?
Senhora Cusco, por gentileza, a senhora pode me mostrar no mandato se alguma incidente aconteceu depois de 21 de dezembro de 2019?
Otherwise, I don't believe that I have the authority to revoke any release in that case due to the date.
Caso contrário, eu não tenho autoridade para qualquer liberação baseado na data.
Since all the dates aren't listed, can we have 24 hours to supplement?
Nós temos 24 horas para fornecer os complementos.
No, because that's not for probable cause.
Não, porque isso não é causa provável.
However, your office has other methods for having bond revoked, specifically motions to revoke bond or motions for pretrial detention.
Porém, existem outros métodos para revogar a fiança. Existem moções para revogação de fiança.
So I'm going to deny that request because the state has other methods to do so.
Então eu vou negar essa solicitação porque existem outros métodos para fazer isso.
As it relates to proof evident presumption great,
relacionado à prova,
I don't find proof evident presumption great based on the information in the affidavit for the warrant.
Eu não consigo ver nenhuma prova para o mandado.
So I'm not going to be able to make that finding.
Não vou poder fazer essa liberação.
Mr. Paulino da Silva, you're not to have any contact with any victim, witness, or any of the victim's family members.
Senhor Paulino da Silva, o senhor não deve ter contato com a vítima, com nenhuma testemunha ou família da vítima.
You're not to have any contact with any minor child under the age of 18.
O senhor não deve ter contato com nenhuma criança abaixo de 18 anos.
No weapons or firearms or any ammunition.
Não, nenhuma arma ou munição.
You're not to go within 500 feet of the victim's residence.
O senhor não pode se aproximar mais do que 500 pés da casa da pessoa que está se defendendo, da vítima.
You may not possess or consume any alcohol or any illegal substances without a valid prescription.
O senhor não pode nem possuir, nem consumir álcool ou substâncias controladas sem uma receita médica.
Mr. Paulino da Silva, do you own a passport?
Senhor Paulino da Silva, o senhor tem um passaporte?
Meu passaporte está com o meu marido. Meus
My
documentos.
passport is with my husband.
Okay. And does your husband have access to the passport? Is it in Orlando?
Seu marido tem acesso ao passaporte em Orlando?
Sim, está com meu passaporte, drive license, tudo. Todos os meus documentos estão com ele.
Yeah, he has my passport, my driver's license, all my IDs.
Okay, so I'm going to require that if you are released from the Orange County Jail, that you are to surrender your passport to the clerk's office within 12 hours of your release.
Senhor, eu vou solicitar que o senhor vai ser liberado no condado de Orange e o senhor tem que nos dar o seu passaporte dentro de 12 horas depois da sua liberação.
Your bond on count 1 is $75,000.
A sua fiança para o crime número 1 é de $75 mil.
Your bond on counts 2, 3, and 4 are $10,000.
A fiança nas ofensas número 2, 3 e 4 é de $10 mil.
Counts 5, 6, 7, and 8 are $5,000.
Ofensas 5, 6, 7, 8, $5 mil.
You also have an immigration detainer.
O senhor também está sendo detido pela imigração.
And so you will not be able to be released even if you pay your bond until the immigration detainer has been lifted.
Então o senhor não pode ser liberado mesmo com o pagamento da fiança até que o detentor da imigração, essa detenção da imigração seja retirada.
And so if you have questions about that, you can contact the Public Defender's Office.
Se o senhor tiver alguma pergunta, o senhor pode entrar em contato com o escritório do defensor público.
And they can help you with that.
E eles podem lhe ajudar com isso.
All right, anything else further from the parties? No, Your Honor.
Mais alguma coisa?
All right, thank you, Madam Interpreter.
Thank you for using our services. You have a good day, Your Honor.
All right, you too. Thank you, sir. Good luck. All right, good morning, sir. Tell me your name, please.
Ricardo Mervin.
Okay.
Still trying to figure out why I'm not coming here.
It's the writ of attachment.
Do we know what case this is? I don't have.
It's a writ of attachment.
Oh, okay.
Great.
Okay. I did see it. Okay, there it is. Mr. Marvin, okay. All right, Mr. Marvin, you're here in case number 2005 DR 1588, and you were picked up on a writ of attachment. You're going to be released, and you are going to have to appear at a court hearing on August 13th, 2020 at 9 a.m. You're going to get this information when you get released. It's a contempt hearing. And if you don't appear, the court can issue a second writ of attachment. And so you need to make sure that if you need to call in or be there in person, because the courts are going to be, we're sort of half open, but we're going to be closing again. So make sure that you call the judge's judicial assistant, whoever the judge is, to make sure that you don't miss any court hearing, okay? So you are going to be released as to this case. All the information that you need is on the piece of paper that you're going to get. It looks like it's a telephonic hearing, so it gives you the phone number and where to call and what you need to do on what day. So don't miss that hearing, okay?
Thank you, ma'am.
All right, I signed all these, so, okay. All right, good morning. Tell me your name, please.
Austin Meadows.
Okay, Mr. Meadows, this is a recall from yesterday, 2020 CF 7654AO, and we reset for probable cause based on the lack of information in the affidavit. And I was provided documentation from the state. I believe that was provided to the public defender's office as well. Ms. Fusco, I've read everything, but none of it is under oath, and there's no jurat with anything.
We've requested jurats, Your Honor, and since this was a felony case, could be called for the afternoon session and allow us to get the jurat.
That's fine. I'll reset it for the second session. I don't know when we're starting the second session, so if you can get the jurats, and then when you get them, forward them to myself and to Ms. Custon, or is there somebody else going to be here this afternoon?
It'll be me.
Okay.
Thank you.
So, and so we'll do the same as well for Mr. Ochino, because it's the same affidavits, and I don't have anything that's sworn under oath.
Your Honor?
Yes.
With Ochino, he refused to come to court.
Okay. Well, we'll deal with it second session at the same time. So, Mr. Meadows, we're going to call you back second session, okay? All right,
Okay.
so we'll recall both of these this afternoon. All right, good morning, sir. Can you tell me your name, please?
Robert Carey Taylor V.
Okay. All right, Mr. Taylor, you are here in 2020 MM 298AA. You're charged with petty theft as a subsequent offense. And I do find probable cause for that offense, and I'll appoint the public defender. I don't know if the state will have an offer for you today.
No, Your Honor.
Okay, so the state does not have an offer, Mr. Taylor, to resolve your case. Is that because it's enhanceable? I'm not showing any. I'm not showing any prior. Oh, what? There is a prior theft conviction on the.
Under the Florida convictions?
Yeah. Is it because it's enhanceable?
Yes, Your Honor.
Okay. So, Mr. Taylor won't be able to resolve your case today. So what I'm going to do is order that you're not to return back to the Wawa at 1615 South Orange Blossom Trail. No contact with any victims or witnesses, and abide by the trespass warning. I'm going to stay the bond at $500. You're out on bond or out on release, pretrial release in 2 cases. I'm not going to revoke that. I'm going to still order that you report to pretrial release.
Yes, ma'am.
In both of those cases. But Mr. Taylor, I'm going to give you a warning because you've got 3 cases now. Chances are you come back. If I see you, I don't know about what any other judge might do, but it's not
Yes,
going to be
ma'am.
great.
I understand.
Okay?
Yes, ma'am. Thank you very much.
Your Honor, the next person on the docket, Aaron Zimmerman, medical.
Okay. Sorry, let me get my paperwork together here. Okay, so Zimmerman is medical.
Yes, Your Honor.
Okay. And so we have, looks like this was reset for, she was in the hospital, and now she's medical. Is it medical, like she's not coming medical?
Yes, Your Honor.
Okay. All right, so I'm going to appoint the Public Defender's Office in both the cases 2020 CF 5602AO and 2020 CF 7570AO. In 5602AO, she's charged with possession of cocaine, and I do find probable cause. And in 2020 CF 7570, it's possession of fentanyl, possession of drug paraphernalia, and possession of cocaine. And I do find probable cause for those offenses. I'm sorry, Ms. Custon, did you want to waive?
Yes, Your Honor.
Okay, I apologize. So she's, looks like on the warrant for the cocaine, she was ordered not to return back to the scene of the offense, and no drugs or alcohol or any illegal substances or controlled substances without a valid prescription. I'm going to reduce that bond to $1,000. And in the other case, I don't believe that was a warrant. And so no drugs or alcohol without a valid prescription. The bond will stay at $1,000, $100, and $150. All right, good morning, sir. Tell me your name, please.
Good morning, Your Honor. It's Vernon Scott Andrews.
All right, Mr. Andrews, you're here in case number 2020 CF 7711AO. You're arrested for battery on a person 65 years of age or older. And I do find probable cause, and I will appoint the public defender to represent you. Do we have any witnesses here for Mr. Andrews?
No, Your
No.
Honor.
Okay. So, Mr. Andrews, I'm going to have you sign the no contact order form. You're to have no contact directly or indirectly with the victim. I understand that it's your mother, but she's not here today to tell me that she wants to have contact. So that will have to be changed in writing by a judge at a later day, and the public defender can file any of those motions for you.
Okay, I understand.
All right. You're to maintain a separate residence. If you need to go back to the residence to get personal belongings, you must go with law enforcement. You can go one time. You're not to possess any weapons or firearms or any ammunition. And it looks like the Department of Children and Families was contacted, so you'll have to comply with any investigation that they may have. You do qualify for pretrial release. I'm going to release you to pretrial release. Make sure you follow those conditions that I've instructed you on, as well as what they're going to tell you to do, okay?
Oh, okay.
All right. You'll get out today.
All right, thank you, Your Honor.
All right. Good luck. All right. Good morning. Tell me your name.
First name Edward Joseph Carberry.
All right, Mr. Carberry, you're here in 2020 CF 7712AO. You're arrested for child abuse. I do find probable cause for that offense, and I'll appoint the public defender. Is there any witnesses here for Mr. Carberry?
No, Your Honor.
Okay, Mr. Carberry, I'm going to order that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order, please. Did you understand everything on the form?
Yes, ma'am.
Okay, you must maintain a separate residence from the victim. If you need to return back to the residence, I don't know where the victim's living, but if you need to go back there and the victim is living there, then you need to go with law enforcement one time to get your things, okay?
Yes, ma'am.
It looks like DCF was contacted, so they may have an investigation. You have to comply with that. No drugs or alcohol without a valid prescription, and no weapons or firearms or any ammunition. I am going to set the bond at $1,000 with random urinalysis. I don't know if they're going to make you do the random urinalysis, but they may. So if you need to come in and take a test, then you're going to have to make sure that you're not test dirty, okay?
Mm-hmm.
All right, did you understand? All right. Good morning, sir. Tell me your name.
David Descent.
All right. Mr. Descent, you're here in 2020 CF 7713AO. You're arrested for burglary of a dwelling with an assault or battery, attempted sexual battery, battery, domestic violence, and resisting an officer without violence. And I do find probable cause for those offenses, and I'll appoint the public defender. Ms. Fusco, count 1 is punishable by life felony. Count 2, I believe, is an F2 or an F3 as an attempt. Did you wish to be heard as to bond on count 1?
We would just ask the court to consider all the facts in the affidavit to find proof evident or presumption great and hold them with no bond.
All right, Ms. Custon?
Your Honor, I defer to the court.
All right, I do find proof evident, presumption great based on my review of the affidavit. Mr. Descent, I'm going to hold you at no bond on count 1. Your attorneys will be able to file a bond motion downtown in order to try to get you a bond on that count. Count 2 will be set at $7,500. Count 3 will be $500. And count 4 will be $100. So you're not to return back to the victim's residence, so where the alleged offense is alleged to have occurred. No contact directly or indirectly with any victim or witness. I'll have you sign the no contact order form, please. Did he sign that already? Can't hear anybody. Okay. Did you understand everything on that form, Mr. Descent?
Yes, ma'am. Can I say something too?
Well, I would be very careful what you say. Anything that you say can be used against you. And my guess is that if you want to start talking about what you think happened or what didn't happen,
I'm good.
So call your attorney, tell them everything that you want to tell them, all right? No drugs or alcohol without a valid prescription, no weapons or firearms or any ammunition. And I am going to revoke the release in 2020 MM 4410 and 2020 MM 1488. And I believe the PD has previously been appointed in both of those cases. Oh, we'll see. I have that they were in one, but I'm not sure about the other. Okay, so we'll appoint them in 1488 so they can file any appropriate bond motions for you. All right, thank you, sir.
Good morning, Your Honor.
Good morning. Hold on one second. All right, tell me your name, please.
Fudge, Jacob Fudge.
All right, Mr. Fudge, you're here in 2020 CF 7695AO. You're arrested for tampering with a witness to hinder communication to law enforcement and battery domestic violence. Did you
Yes.
find probable cause for those offenses? And I'll appoint the public defender. Do we have any witnesses here for Mr. Fudge? No.
No.
Okay. So, Mr. Fudge, I'm ordering no contact directly or indirectly with the victim. I'll have you sign the no contact order.
All right.
Do you understand everything on that form?
No, yes, Your Honor.
All right. You're to maintain a separate residence.
We'll just sign right here.
It looks like you both have the same address.
Yes, Your Honor.
do you need to go back to that residence to get personal belongings?
Yeah, I still got like clothes and stuff there, but yeah, I could have like one of my family members or like.
Well,
you know.
no. None of your family members.
I-
If you need to go back, you
Oh.
must be with law enforcement, and you can go one time with law enforcement to get those things.
All right.
Okay?
Yes.
And no weapons or firearms or any ammunition. Your bond on count 1 will stay at 1,000. Count 2 will also be 1,000. You're also out on release, the same victim, and there's also a no contact order in that case.
All right.
And so 2020 MM 3391AO, I am revoking the bond and setting that at none at this time. The public defender, or you have an attorney in that case, I think it's the public defender, they're going to have to file a bond motion for you in that case.
All right.
All right?
All
Thank you,
right.
sir.
You're welcome.
All right, good morning. Tell me your name, please.
Derek Gordon.
All right, Mr. Gordon, you're here in 2020 CF 7714AO. You're arrested for aggravated assault with a deadly weapon, domestic violence, and battery domestic violence. Do find probable cause for those offenses, and I'll appoint the public defender. Are there any witnesses here for Mr. Gordon? No?
No, ma'am.
All right. Mr. Gordon, I'm ordering no contact directly or indirectly with the victim. I'll have you sign the no contact order, please. Do you understand everything on that form, Mr. Gordon?
Yes, ma'am.
All right. You're also going to maintain a separate residence from the victim. If you need to go back to the residence, you must go one time with law enforcement. Don't go by yourself, okay? No weapons or firearms or any ammunition. If you have any firearms or any weapons, you must surrender them within 6 hours of your release to your local law enforcement agency. And you do qualify for pretrial release. I am going to release you to pretrial release. If you violate any of those conditions of release, it's a new law violation, okay? So make sure that you follow those orders and PTR's requirements, okay?
Yes, ma'am.
Your Honor,
Yes.
the next person on the docket, Jeremy Johnson, refused court.
All right. Are there any witnesses here for Mr. Johnson?
No, Your Honor.
Okay. All right. I'm going to find his refusal to be a waiver and absenting himself from the initial appearance. I'll appoint the public defender. And Ms. Custody, did you want to formally waive?
Yes, Your Honor.
All right. So 2020 CF 7706AO. It's aggravated battery with a deadly weapon and battery domestic violence, and I do find probable cause. And so there's no contact directly or indirectly with the victim. Maintain a separate residence, one-time return with law enforcement, and no weapons or firearms or any ammunition. Based on the facts as well as the criminal history and the failures to appear, the bond on count 1 is $10,000. Count 2 is $500.
And the next person on the docket, Dominic Knight Lewis. She's not coming due to behavior,
Okay.
but I think she has a let me make sure.
We have a witness present for Ms. Knight Lewis?
No,
No?
Your Honor.
Okay. So she's unable to behave to come to court. I'm going to find that behavior to be a waiver. I'll appoint the public defender. Ms. Custon, did you want to waive?
Yes, Your Honor.
Okay, 2020 CF 7708AO. It's a violation of the no contact order. And that is the no contact order in 2020 CF 1503, excuse me, out of Osceola County. And so there is probable cause. And so she's to have no contact directly or indirectly with the victim, maintain a separate residence. She's not to return to where the offense is alleged to have occurred. No weapons or firearms or any ammunition. The bond will be set at $1,500. I'm revoking 2020 CF 1503. Looks like, I don't know if she has the public defender in that case. If not, we'll appoint them. And they can file any appropriate motions. All right, good morning, sir. Tell me your name, please.
Good morning. My name is Travius Polite.
All right, Mr. Polite, you're here in 2020 CF 7683AO. You were arrested pursuant to a warrant in which probable cause was found for home invasion, robbery with a firearm, aggravated assault with a firearm, domestic battery by strangulation, and tampering with a witness to hinder communication to law enforcement. And I'll appoint the public defender to represent you. We do have a witness here. Ma'am, can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Can you state your name for me and then spell your last name?
Leola Lachey Cooper, married name Polite.
Sorry?
Married name Polite.
Okay. Can you spell your last name for me, please?
Cooper.
All right. Ms. Cooper, how do you know Mr. Polite?
We are married. We've been together for 20 years.
Okay. And does Mr. Polite live with you?
Yes, ma'am. And I want to, we got into it Saturday, and I told him if he didn't come home, I was going to make a false report on him.
Okay. Are you afraid of him?
No, ma'am. That's my husband. I do the touching more than he.
Do you want to have contact with him through the pending of this case?
Yes, sir. Yes, ma'am, if he would like to have contact, even though I put false charges on him.
And you're telling me there's been violence in your relationship in the past?
No, ma'am.
Well, you just said that you hit him more than he hits you.
Like when I get upset, I get I have anxiety and I take medication for bipolar and schizophrenia, and I get mad.
So you're saying that this did not happen?
No, ma'am. Saturday, we had got into an argument because he told me not to let our oldest daughter do nothing. Like she couldn't go out, and I end up letting her go out with her friends. And he was like, by him being a husband, I don't obey his rules. So he was leaving, and he not coming back. And I told him if he don't be home Sunday, I was going to put false charges on him. If I can't have him, nobody else will.
Okay. Ms. Fusco, do you have any questions for Ms. Cooper?
Could I have a moment, Your Honor?
Okay. Ms. Custon?
No, Your Honor.
Okay. And thank you, Ms. Cooper, for your testimony. And so count 1 is a punishable by life felony. Ms. Fusco, I don't know if, in light of the victim's testimony, if you wish to be heard as to bond on that count.
I'll defer to the court, Your Honor.
Okay. So, Ms. Custon?
Yes, Your Honor. Based on the sworn testimony from the alleged victim, we argue that proof is not evident and presumption is not great. We ask a bond be set and it be reasonable as the victim stating that it was a false report.
All right. And based on my review of the affidavit, based on just the affidavit, I don't find proof evident presumption great. And then in addition, in light of the victim's testimony, I don't find any additional proof evident presumption great either. But based on the testimony and the relationship, I am ordering no contact. So, Mr. Polite, I'm going to have you sign the no contact order form. You can't have any contact directly or indirectly with Ms. Cooper. If she tries to contact you, you need to walk away, okay?
Yes, ma'am.
Don't answer the phone. Because that could get you in further trouble. There's the no contact order, okay?
Yes, ma'am.
I can't control what she does, but that's on you, okay?
Yes, ma'am.
All right. So you're also to maintain a separate residence. If you need to return to the residence to get any personal belongings, you must be with law enforcement. You can go one time with law enforcement to get your things. You're not to possess any weapons or firearms or any ammunition. I don't know if you own any firearms or any weapons, but if you do, you must surrender them within 6 hours of your release from the Orange County Jail.
Yes, ma'am.
DCF was contacted, so if there is an investigation pending, you'll need to comply with that investigation.
Yes, ma'am.
You may want to get in touch with your probation officer and let them know about the testimony here today, okay?
Yes, ma'am.
Because I don't know if they'll violate your probation. All
Yes,
right?
ma'am. Yes, ma'am.
Okay. I'm going to set your bond on count 1 at $5,000. Count 2, it'll be $150. Count 3, $150. And count 4, $150. You think you're going to be able to make that bond?
No, ma'am.
No? All right. Are you working at all?
No, I was going to school. Until
Going
the
to
corona.
school?
Yes, I was going to
So-
school for HVAC until the corona.
What kind of a bond would you be able to afford?
Really, none right now because all my money was going towards my family. Like,
Do you have any family here other than your wife?
not really. Not that could really help me. No, ma'am. My wife.
Well, I have like $300. I can give it to his mama that he had at home.
All right, I'm going to set the bond at $3,000 on count 1. The remaining bonds will stay at the $150. Mr. Polite, if you're, I don't know if they're going to file a violation of probation. They didn't file an on-view VOP, but if they do, we'll address that at another time.
Yes,
He just has a 5-day hold.
But you do have a 5-day hold because of the violent felony offender of special concern, and I don't believe that I can release that. No, legally under the law. So you'll be here for a couple days in the Orange County Jail.
Yes, ma'am.
But in the meantime, I would get in touch with the public defender and your probation officer. And if you can't make that bond, then your attorneys will be able to file a motion. I'm sure Ms. Custon's writing all of this down to speak with whoever is assigned to your case. All right, Mr. Polite?
Yes, ma'am.
Okay, thank you.
I have a question.
Yes.
Are he allowed to talk to his kids?
Yes, I'm not, but he can't communicate through his kids to you. And you can't communicate to him through the kids, so but he can speak with his children. It's just you that he can't contact. Okay? All right, thank you. All right, good morning, sir. Tell me your name, please.
Byron Louder.
Mr. Louder, you're here in 2020 MM 4580AO. You're arrested for domestic violence battery. We do find probable cause for that offense, and I'll appoint the public defender. And we do have a witness here. Ma'am, can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And tell me your name and then spell your last name for me, please.
First name Taquisha, last name Black. Black.
Okay, you may need to get a little bit closer to the microphone. I know. If you can move it, maybe. I don't know. And how do you know Mr. Louder?
This is my brother.
And then, do you all live together?
No, we don't.
Okay. Are you afraid of him?
No.
Do you want to have continued contact with him through the pending of the case?
Yes, because I didn't write a statement because it was a small misunderstanding. However, the cop said that he had to be arrested because he witnessed something, but it was never any battering, any punches thrown, any altercation, actually.
Okay, so you're not afraid of him?
No.
And is this just sort of playing around with your
Yes.
brother? Okay. And has there been any violence in your relationship in the past?
No, never.
Okay. It's the first time law enforcement was involved in your relationship?
Yes.
Okay. And if something were to happen in the future and you felt threatened or he did batter you, would you call law enforcement?
Yes.
Okay. Ms. Fusco, do you have any additional questions?
No, Your Honor.
Ms. Custon?
No, Your Honor.
Okay. I am going to allow contact. It's non-hostile, non-violent contact, Mr. Louder. So that means, even playing around with your sister, probably not a good idea, okay? So just give her a nice hug. No getting in her face, no mushing her on her face, no saying disrespectful things to her, no pushing her, biting her, slapping her, kicking her, any of that, okay?
Yes, ma'am.
Okay. You're not to possess any weapons or firearms or any ammunition. Do you think any drugs or alcohol had any involvement in anything, any behavior? Okay, because there's an allegation here that you thought that he was drunk and you were trying to get him to go inside the vehicle, and that's kind of how. No. Okay. I'm still going to order no drugs or alcohol without a valid prescription, okay? He does not qualify for pretrial release, correct?
He didn't qualify due to the out on bond case.
Okay. All right. So I'm going to set the bond at $500. I'm not revoking the release in your other case. Looks like you had a court date today, a case management conference.
It got pushed back to November, ma'am.
Okay. I just want to make sure. Do you know, Ms. Custon, if you represent him in the other case? No, it's 2019 CF 17312. Yeah, the PD does represent you. It looks like pre-trial. Did you say November?
Yes, ma'am.
Okay. Make sure that you don't miss any court dates. You keep in touch with the public defender's office and don't get arrested. Okay?
Yes, ma'am.
All right. Thank you. All right, please tell me your name.
Jamira Patterson.
All right, Ms. Patterson, you're here in 2020 MM 300 AA. You're arrested for domestic violence battery. I do find probable cause, and I'll appoint the public defender. I don't think that we have any other witnesses here in the gallery. And so I'm going to order, Ms. Patterson, that you have no contact directly or indirectly with the victim.
Okay.
That can be changed in writing by a judge at a later day.
Okay.
So you need to make sure that no contact.
I have
Yes?
a question for you.
Okay, just don't talk about the facts of the case, okay?
Okay, but he actually lives with me. But the house is under my name, like only my name is on the lease. So how do I go about that?
Okay, so that's a civil issue because if he's been living there for a certain amount of time, he may have established some residency. If I don't know what your lease says, if he's allowed to live there or not, but that's a civil issue, and I don't get involved in that. Okay. So what I'm just going to do is order that you maintain separate residences.
Okay.
So that'll have to be sorted out, but you can't have contact with him until that order's changed in writing. So you'll have to either contact an attorney about the civil issue, but I can't kick him out of the residence if he is staying there, okay?
Yeah.
You may return if you need to go back there with law enforcement to get things, but if he's there, you can't be there.
Okay.
You're not to possess weapons or firearms or any ammunition. I do see the Department of Children and Families was contacted, so they may have an investigation, I don't know, but you'll need to comply with any investigation.
Okay.
Did she end up qualifying?
She qualified.
Okay, I'm gonna release you to pretrial release.
Okay.
Make sure you comply with my orders as well as their conditions, okay?
Yes, thank you.
All right, good luck, ma'am. All right, please tell me your name. Can you tell me your name, sir? Keep the mask on, please. Thank
Marvin
you.
Paul.
Okay, Mr. Paul, you're here in 2020 MM 4597AO. You were arrested for dating violence battery. I do find probable cause, and I will appoint the public defender. And we don't have any witnesses here for Mr. Paul. Nope. Okay. So I'm going to order that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order, please. Did you understand everything on the form, Mr. Paul?
Yes, ma'am.
Okay. You're also to maintain a separate residence. If you need to return back, it doesn't look like you have the same residence here. It looks like it's your residence where the alleged event is alleged to have occurred. Is that your residence?
Yes, ma'am.
You don't live together?
No, we don't really live together.
Okay. So just maintain a separate residence. You're not to possess weapons or firearms or any ammunition. And your bond is set at $1,000. Looks like, does he have a 5-day hold and a hold for Alachua?
He has the warrant for Alachua.
Okay.
It's a
Looks
hold.
like you have a warrant for Alachua County, so you'll have to, it's on a violation of probation. So will I see him on that?
It's a hold, so it has to be
it's just a
served.
hold. Okay. So you'll have to call the public defender if you have questions about that, okay?
Okay.
The next person on the docket yonder, Fernando, medical.
Okay, we're calling his attorney.
Oh,
Be on the phone. Mr. Bark, this is Judge Wish. Are you there?
Good morning, Judge Wish. How are you?
I'm good, thank you. How are you?
I'm doing well, thank you. Thank you for allowing me to appear by phone. I appreciate it.
No problem. So it looks like your client, and is it Bana Fernand?
They have his name backwards. It should be Fernando Bina.
Okay. He is medical. I'm not sure what the medical issue is, but we've got a lot of medical. But I can still do the initial appearance if you want to waive his appearance.
I will waive his appearance.
Okay, and let me just get my paperwork here together. All right, now did you already file a notice of appearance, or are you intending to do that?
Well, is this on the new case or is this on the one that
So this is
from the 2017 case?
Yeah, so this is 2020 CT 3935, but they do have the hold on him because he has an out on release case. He has the out on bond case from 2017.
Okay, so my
Which I
understanding
believe you
was
represent him on that case.
that is correct. I do represent him on the 2017 case. I have not filed a notice of appearance on the 2020 case, but I have been retained to do so. We just haven't been able to get that filed yet.
Okay, I just want to make sure that somebody, he's not.
No, we're on the case.
Okay. What's going on with the 17 case? Because it's just see a lot of hearings, but obviously we've been closed. So has there been any hearings going on?
Yes, my understanding is that the hearings are pending in that matter. There's an interesting issue that's come up, though, which is Judge Dubois discharged the bond in March on that case. So I don't know if that affects the ability of the court to revoke his bond or keep a hold on him.
I just wanted to know the status of the case, if it's just set for motions. It looks like they were set off and set off and set off.
Right. These are all the intoxilizer motions, and my understanding is that they've been set off due to the pandemic right now.
Okay. All right. So I do find probable cause for the DUI with property or property damage or personal injury. I don't believe there was any personal injury, but it was just property damage. And you're going to file a notice of appearance. So he's not to possess or consume any alcohol or any illegal substances without a valid prescription. I'm also going to require that he have random urinalysis through pretrial release. I don't know if they're calling them in because of the pandemic, but if he is required to come in and if he tests positive for any drugs or alcohol and he doesn't have a prescription, then that would be a violation of his release. Because the case that he's out on release is so old and it appears as though you're all working hard to get those motions set and you haven't been able to, I'm not going to take any action on that today.
Your Honor, may I ask a question about that?
Sure.
When you say you're not going to take any action, does that mean the hold will be removed?
Yes, the hold will be removed.
Okay, thank you so much.
I am going to stay the bond at the $1,000 on the new law violation. You may want to advise your client that if he violates any condition of any release in any of the cases, it's likely that his bonds will be revoked.
I will certainly let him know that.
All right, anything else?
No, just my appreciation and gratitude, Your Honor.
Okay, thank you. Have a great day.
You too. Take care.
All right, thank you. Okay, now we've got arraignments. A sip of drink. Okay. All right. Please tell me your name, sir.
Willoughby Bowen Jr.
All right, Mr. Bowen, you're here in 2020 MM 3788AO, and the Office of the Public Defender was previously appointed to represent you in your case. Looks like the state did file an information charging you with trespass on property other than a structure or conveyance. It's a misdemeanor of the first degree alleged to have occurred on or about May 24th, 2020. Do we know if this case is resolvable today?
Your Honor, if the client seems competent today, we have nothing pending. And if he wants to resolve.
Okay, so you're not on probation, Mr. Bowen?
No, I'm not.
Okay. And there's no attached felony or anything like that to it? Okay. I'm showing 31 days in.
Our offer was adjudication of guilt 31 days with 31 days credit time served, court costs, no return to scene of the trespass, abide by the trespass warning, and there was no cost of investigation.
Okay, Mr. Bowen, the state's offers credit for time served, and obviously you got to abide by the trespass warning. You can't go back to 928 South Ivy Lane, that Dollar General. You've been trespassed, and then I would give you a year to pay your court costs. Do you want to resolve your case today?
Yes, I do.
Okay. Did you read that plea form before you came into court, or right now?
Yeah.
Is that a yes?
Yes.
Okay. Did you understand everything on the plea form?
Well, not quite everything, but I understood enough.
Okay. I didn't hear you. Didn't understand everything?
I understood enough of it.
Well, I need to make sure that you understand it all. So what is it that you don't understand? I'm happy to try to explain it to you.
Well, I understood enough.
Well, that's not good enough for me. So tell me what you don't understand.
Well,
Are you able to read and write English, Mr. Bowen?
yes, I am.
Okay. Is it difficult for you to see?
Excuse me?
Is it difficult for you to see because of the small writing, or?
Well, it's not difficult to see.
I'm sorry, it's really hard for me to hear him. I don't know if he
It's not
can
difficult
speak
to
in-
see, but I just understanding this part.
Okay, what don't you understand? So there's certain rights that are listed out on there that you have constitutional rights, like you have the right to ask the state to prove to the charge beyond a reasonable doubt to a jury or to a judge. You have the right to confront witnesses against you. You have the right to remain silent and not testify. So there's a whole bunch of rights that you're giving up when you enter the plea. Do you understand all those rights that are listed out on the plea form?
Yes, I do.
Okay. Is there anything that you don't understand?
I understand enough. I understand enough.
Okay. Tell me what you don't understand.
So,
Because that's not an absolute. It's just saying that you understand enough. Do you understand who I am?
excuse me?
Do you understand who I am?
Yes,
What
I
my
do.
job is?
Yes, I do.
Okay, who am I?
You're the judge.
I'm sorry?
You're the
You gotta
judge.
speak up.
You're the judge.
Okay, and what do I do?
Judge whether it's right or wrong or what should be done.
I can't hear anything he's saying over there.
You judge what is right or wrong or what should be done and what should be done about it.
I can't hear anything. It's just right or wrong.
You judges what is right or wrong or what should be done about it.
You say you
Ms.
judge.
I believe he's right or wrong, and then the judge decides what to do about it, whether or
Okay,
not.
how do you hear? I can't hear anything.
Is that what he said?
Yes, yes.
Okay.
Okay, all right. And then, do you understand what you're charged with?
Yes.
What are you charged with?
I can't quite remember what exactly what it, but I do understand what it one charged with.
Can you all hear that?
He doesn't quite remember what he was charged with.
Okay, so you're charged with trespass on property other than a structure or conveyance, and that was at the Dollar General at 928 South Ivy Lane on or about, looks like May 24th, 2020. And you've said that you want to enter a plea to that offense. So, do you have any questions about anything on the plea form?
No, I don't.
Said no, Your Honor.
I can't hear any. If you're not near a microphone, I can't hear you.
No, I understand.
He said he understands.
Okay. All right. Are you on probation, Mr. Bowen?
No, I'm not.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, I understand.
Okay. I find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 31 days with credit for 31 days time served. Can't go back to the Dollar General, 928 South Ivy Lane. If you go back there, you'll probably get arrested, so don't go back. I'll order you pay your court costs by June 23rd, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck, Mr. Bowen.
Thank you, ma'am.
You'll get out today, unless there's nothing else holding him, right?
No, Your Honor.
Okay.
Come on. Come on.
All right. Good morning, sir. Tell me your name.
Junior.
I'm sorry, I can't hear you.
Maurice Maxim Jr.
Okay, Mr. Maxim, you're here in 2020 MM 3553AO. The PD was previously appointed to represent you. The state filed an information charging you with a battery. It's alleged to have occurred on or about May 16th, 2020. And I don't know if the state will have an offer today.
No, Your Honor.
And he's on probation.
He's on probation.
And at this time, we'd like to enter a plea of not guilty.
Okay. So, Ms. Custon, is there, I mean, because the next, all the cases I have except Mr. Bowen's are DV batteries and batteries, which we know are not going to get resolved.
Well, Your Honor, I heard yesterday about doing the waiver, and we definitely could. We're very short-staffed, and we get the the docket the day before. So if we see it, yes, I'll let them know to waive it. But if they're doing it the morning of, it might not come through in time.
All right. So you don't know when the informations are filed, or no? Because they don't set them the next day.
I mean, these are already dispersed to everyone, so they could file it. We'll let them know that it's up to them. But by the time it comes to me and my, domain, I waive one for tomorrow because I saw it.
Okay.
And it is a good idea. I agree with you.
Yeah.
So I'll let everyone know.
Okay. So, Mr. Maxim, we're not going to be able to resolve your case today, and so your attorney over here has entered a plea of not guilty for you. So we'll give you some dates, okay, for your next court date.
Division 62, pretrial conference with July 16th at 9:30 a.m. courtroom 9B.
Okay.
Your Honor, the next person on the docket, Manic Robinson Medical.
Okay, so that's 2020 MM 394780, and the PD was previously appointed. It's a DV battery. It would not get resolved today anyway. Ms. Custon, did you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 50, pretrial conference date will be July 13th at 2:30 p.m. courtroom 7C.
Your Honor, the next person on the docket, Isaac Schaffner Medical.
No return back to 4692 Sutton Terrace in Orlando, Florida. That's the alleged scene. That's the no contact with any victims or witnesses, no weapons or firearms or any ammunition. Based on the facts of the case, I'm going to set the bond at $500, but I am going to revoke the release. 2020 CF 5870AO, and I'll appoint the public defender if they weren't previously appointed in Mr. Doddard's case. And, oh, there, brought a new one. This pen died, and then this pen. There we go. All right.
And Kelly, hospital, Your Honor.
Okay, we will reset Kelly within 24 hours of release from the hospital.
Montalvo Medical.
Okay.
And Your Honor, if you would appoint us, we can waive his appearance.
Okay. So, Mr. Montalvo, 2020 MM 4598AO, it's a trespass on property after warning. And I do find probable cause. I'll appoint the PD. They've waived his appearance. So, no return back to the location of the offense. No contact with any victims or witnesses. Abide by the trespass warning. There seems to be a lot going on in this case with these victims, and It's not just your run-of-the-mill trespass here. I'm gonna stay the bond, but I am revoking. So the bond will stay at 500. 2020 CF 6999AO. The PD was previously appointed. Any motions can be filed. Also, can you add no weapons, firearms, ammunition? Abide by the trespass.
Okay.
All right, good morning or afternoon. Tell me your name, sir.
Stephen Young.
All right, Mr. Young, you're here in 2020 MM 4584.
Yes.
You were arrested for trespass on property after warning, and I do find probable cause. And Ms. Fusco, did you have an offer? I think there's, do we know if the other case has been filed on? Are you on probation, Mr. Young?
No.
Okay. Hold on just a second for me. I don't know if we can resolve both of your cases today, if you wanted to try to do that. Looks like the state did file an information, and a written plea of not guilty was filed by the PD. So, do you want to resolve both of your cases today, Mr. Young, and you don't have to go back to court?
Yes.
Okay, and you know what the other case I'm talking about is?
No, they just said I was trespassing pretty much.
Yeah, it was a trespass, 2020 MM 8580. The trespass from the Publix at 12195 South Orange Blossom Trail
Yeah.
from January 4th, 2020. Ms. Fusco, do you have a global offer? I think he's got how many days in the other case? I think he was arrested on like the 3rd or the 4th, and he bonded out on the 17th.
You got 13 days.
Huh?
13 days.
13 days.
I was going to offer on the earlier case, adjudication of guilt, 13 days or 13 days credit time served, court costs, no return to the scene of the trespass. But as he has a history with repeats to this current location, I was going to say adjudication of guilt, 4 days with credit time served, court cost, no return to the scene of the trespass.
And does he have 1 day or 2 days in right now? 2?
Yes.
Oh, okay, so that would get you out tomorrow. So, Mr. Young, if you wanted to resolve both cases, the first case that you were arrested back in January would be credit for time served. So you had 13 days in on that, so that would be credit for time served. And then the new case would be 4 days with credit for 2, so that would get you out tomorrow.
Okay.
Do you want to do that?
Sure, yes.
Okay. Did you read the plea form before you came into court?
Yes, ma'am.
All right. And did you understand everything that was on it?
Pretty much, yes.
Okay. What didn't you understand?
What's the difference between pleading guilty and no contest?
Okay. Well, if you want to take plea no contest, it means you're not admitting guilt. You're doing it in your best interest. So if you want to enter a no contest plea, that's fine with me. So you're not admitting guilt, but you're saying that it's in your best interest to enter the plea.
Okay, just guilty plea, I guess.
Other than that, there's really no difference unless there's a civil issue involved. And in this case, I don't believe that there would be. So did you understand everything else other than that on the plea form?
Yeah, pretty much, yeah.
Okay. Are you on probation anywhere?
No.
Okay. You understand if you're not a U.S. citizen, the plea will subject you to deportation.
Yeah, yes, sir, I understand that.
Okay. All right, in 2020 MM 8580, I do find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 13 days with credit for 13 days time served. You can't go back to that. I think I said it was a Publix at 12195 South Orange Blossom Trail. Abide by that trespass warning. And then in the new case, 2020 MM 458480, I'll adjudicate you guilty, sentence you to 2 days, or 4 days, excuse me, with credit for 2 days time served, and order that you're not to return back and abide by the trespass at the Big Lots 11230 South Orange Blossom Trail. And I'll order you pay your court costs and fees by June 23rd, 2021. And if you'd like to appeal the judgment and sentences of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you, sir. Good luck, Mr. Young. So that should resolve all your cases, okay?
Okay.
All right, good luck.
All right, thanks.
And Your Honor, for the record, you didn't appoint. So
I didn't appoint on the new one, but you were previously appointed on the other
Thank you.
one. Yeah.
You're next on the list, Monique Armstrong, medical.
Okay. All right, so this is Miss Armstrong. She's medical. I'll appoint the public defender, 2020 CF 7661AO. And Ms. Custon, did you want to waive?
Yes, Your Honor.
All right, so she's charged with battery, with one prior battery conviction. I do find probable cause, and I will order no contact directly or indirectly with the victim, no return back to where the offense is alleged to have occurred, no weapons or firearms or any ammunition. The bond will stay at the $1,500. She's out on release for aggravated assault with a deadly weapon. I am going to revoke 2020 CF 5126AO and set that bond at none. The PD was previously appointed in that case, correct?
Yes.
Okay.
Next we have Timothy Crandall. He refused court.
Okay. Well, he's absenting himself from the initial appearance. So I'm going to find that to be a waiver. 2020 CF 7539AO. I'll appoint the public defender. Ms. Custon, do you want to formally waive even though he's refused to come?
Yes, Your Honor.
Okay. 2020 CF 7539AO. The state filed an information and a judge found probable cause for 3 counts of grand theft 3rd degree. And so no return to any Home Depot and no contact with any victims or witnesses in the case. The bonds will stay $2,500, $1,000, and $1,000. Okay. All right. Good afternoon. Tell me your name, sir.
Brian Crittenden.
All right, Mr. Crittenden, you're here in 2020 CF 7675AO. You're arrested pursuant to a warrant. Probable cause was found for a violation but an injunction with 2 or more convictions. And I'll appoint the public defender's office to represent you. You may not have any contact directly or indirectly with any victim or any witness in the case. No weapons, no firearms, no ammunition, no drugs or alcohol without a valid prescription, and you must abide by the injunction in Seminole County. If we could put that in the court minutes, it's Seminole County case 2015 DR 4897. Your bond is set at $10,000. All right, thank you, sir.
Thank you.
Good afternoon. Tell me your name.
Hello, my name is Chamio Delil.
All right, Mr. DeLille, you're here in 2020 CF 7579. You were arrested pursuant to a warrant for possession of cocaine. And I'll appoint the public defender to represent you. No drugs or alcohol without a valid prescription. I'm going to stay the bond, but I'm not revoking your release on the other case. I don't know. Looks like you have a return date in that case, July 2nd. So make sure you don't miss any court.
Yes,
I'm
ma'am.
staying the bond at 1,000. All right, thank you.
You're welcome. Thank you.
Good afternoon. Tell me your name.
Marcus Fisher, ma'am.
All right, Mr. Fisher. You're here in 2020 CF 7027AO. You're arrested pursuant to a warrant. Probable cause was found for armed burglary of a dwelling with a firearm and grand theft third degree. And I'll appoint the public defender's office to represent you. Count 1 is a punishable by life felony. Ms. Busco, did you wish to be heard as to bond?
Yes, Your Honor. The state asked the court to consider all the facts in the affidavit. The defendant entered the victim's residence through a window and pointed a gun at him. The victim fled to his roommate's room to call the police, could hear the defendant continuing to rummage through his property, and the victim saw the defendant and a co-defendant jump down from the second-story window of his home. The defendant was known by the victim and identifiable. The victim's cell was tracked to a car where the defendant was seen fleeing. Firearms and the victim's property were found in the car where the defendant had been seen running from. The state asked the court to find proof, evidence, or presumption great and hold him at no bond.
Ms. Gustin?
Ma'am.
Your Honor, before I say anything, please, Mr.
Okay,
Fisher,
yes,
don't
ma'am.
say anything at all. It's your lawyer on the video.
Yes, ma'am.
Well, on the audio. You can talk to another lawyer who will have your case and knows more about the facts. I don't want you to say one thing about the case, okay?
Yes, ma'am.
Okay, and Your Honor, we're just going to leave this in your discretion.
All right. I do find proof evident, presumption great based on what's in the affidavit. I'm going to hold him at no bond on count 1. Count 2 will stay at the 1,000. No return to the victim's residence, no weapons or firearms or ammunition, no drugs or alcohol without a valid prescription, and no contact with any victim, witness, or co-defendant. And I am revoking 2020 CF 6379AO and 2020 CF 6380AO. Believe the PD was previously appointed in both of those cases for Mr. Fisher. So Mr. Fisher, contact your attorney, okay, and they will file a bond motion for you.
A bond motion?
Yes.
Okay.
Your Honor, next on the list, Aiden Harold, medical.
Okay, I got 2020 CF 7536AO, and Mr. Harrell is medical. I'm going to appoint the public defender. Ms. Custin, do you want to waive?
Yes, Your Honor.
All right, it's 2020 CF 7536. It's a grand theft third degree pursuant to a KPS. The state filed an information, and probable cause was found. No return back to that Ross Department Store. No contact with any victims or witnesses in the case. And the bond will stay at 1,000. I'm showing active PTR.
He's in on other charges.
Okay, but it's not something that I need to address, right?
No, you are.
Okay.
Your Honor, Omar Tia, medical.
I'm sorry. It's hard to hear when you're not near a microphone.
Matia, he's medical, Your Honor.
Okay, thank you. All right, so that's 2020 CF 7662AO. It's a battery on a corrections officer. And I'll appoint the public defender to represent Mr. Mateus. Do you want to waive, Ms. Custon?
Yes, Your Honor.
All right, and so I do find probable cause for the offense. No contact with any victim or witness, and no weapons or firearms or any ammunition. And he's being held here on an out-of-county warrant?
Yes, Your Honor.
Okay, so the bond will stay at $2,500.
Next on the list, Sheriff Keita McCray, she bonded.
McCray bonded?
Yes, she bonded.
Okay, thank you. We'll take no action on McCray. All right, please tell me your name.
Right and polite, ma'am.
All right, sir, you're here in 2020 CF 7292AO. It's a warrant for trafficking in MDA and possession of drug paraphernalia. So that's trafficking in MDA over 4 grams, under 14 grams, I believe. Or over 14 grams? Yes. Okay. And I'll appoint the public defender to represent you. No drugs or alcohol without a valid prescription. All right, I am going to stay the bond at the 50,000 and the 100. If you're not able to make the bond, Mr. Polite, the attorney will have to file a bond motion for you.
Yes, ma'am.
Okay?
Yes, ma'am.
Your Honor, Michael Rose, he bond. Stand by. Right there.
All right, we'll take no action on Roden.
There you go.
Mr. Rhodes, do we have a? I have Eddie Rhodes.
Come on.
All right, Mr. Rhodes, you got to keep your mask on. Thank you. I know. Okay. Thank you. All right, please tell me your name.
Eddie Ray Rhodes.
Okay, Mr. Rhodes, you're here in 2020 CF 7669AO. You're arrested for petty theft as a third subsequent offense and resisting an officer without violence. And I do find probable cause. And I'll appoint the public defender. You can't go back to the Wawa 1615 South Orange Blossom Trail. No contact with any witnesses or victims at that location.
Yes, ma'am.
And I'm gonna stay the bond at 1,000 and 100, but I'm not gonna revoke your release. I want you to keep reporting to pretrial release. If you come back,
Yes, ma'am.
Mr. Rhodes, you may not get a bond in these cases. Do you understand what I'm saying?
Yes, ma'am.
Okay. All right, tell me your name, please.
Ray Sean Spidell, Your Honor.
All right, Mr. Spidell, you're here in 2020 CF 7680. You were arrested pursuant to a warrant. Probable cause was found for burglary of a structure during the state of an emergency and criminal mischief. And I will appoint the public defender's office to represent you in your case. You're not to return back to any of the locations as named in the affidavit, 1310 West Central Boulevard or 1207 West Church Street. No contact with any victims or witnesses. The bond will stay at 10,100. All right, thank you, sir. All right, tell me your name, ma'am.
Latasha Stewart.
All right, Ms. Stewart, you're here in 2019 CF 8573AO. You're arrested pursuant to a capias for failing to appear for pretrial conference back January 14th, 2020. And the judge did set your bond at none in the case. Does she have the PD? Okay. So I can't change the capias today for you, Ms. Stewart, but you're going to have contact your attorneys and they'll file a motion to set bond for you in Division 16, okay?
Ma'am, I've already did this case.
Well, I don't think the case is closed. Is it still open? Yeah, it's not a closed case.
So I gotta stay in here and go back to court?
Yeah, so well, I mean, your attorneys can file a motion to get you a bond with Judge Barber, but I can't change her capias.
I mean, how much time do I have to do?
That's not up to me. I have no idea, but you haven't entered a plea to it yet, and it hasn't been dismissed by the state. So the case is not over. It's still pending. So if you need legal advice, I can't give you that. You're going to have to call your attorneys.
Okay.
Okay? All right. Good afternoon. Tell me your name, sir.
David Trumbull.
All right, Mr. Trumbull, you're here in 2020 CF 7705AO. You're arrested for aggravated battery with a deadly weapon. I do find probable cause, and I'll appoint the public defender. Can't have any contact with the victim in the case. No weapons, no firearms, no ammunition. That means no knives or anything like that. And I know if I'm not mistaken, based on my review of the affidavit, you may live in the same area as the victim, so you just can't go to the victim's residence, okay? So
I
stay
live
away
there.
from the
He does
victim's
it.
residence. I don't want you to say anything. I'm just listen to what I'm telling you, okay?
Yes, ma'am.
So you have to stay away from the victim, so don't go to the victim's residence. I don't know where your place is in relation to the victim, but you can't have any contact with the victim, okay? So you do qualify for pretrial release. I'm going to release you on pretrial release. Make sure that you comply with their conditions and my orders, okay?
Yes, ma'am.
All right, good luck, sir. All right, good afternoon. Tell me your name.
Joseph Vance.
All right, Mr. Vance, you're here in 2020 CF 7703AO. You're arrested for driving while license revoked as a habitual traffic offender. And I do find probable cause, and I'll appoint the public defender to represent you. You can't drive without a valid driver's license. I'm gonna stay the bond at the $2,500. I'm not revoking your release. So just make sure you keep in touch with your attorney on that case, okay? You don't keep the mask on. You can talk with the mask on. I'm talking with the mask on.
Ma'am, can I say something?
I don't want you to talk about the facts of the case. If you're being recorded.
I know.
So everything that you're saying is, listen to me. Everything that you're saying is being recorded and can be used against you. So if you're gonna talk about what happened or what did not happen, it's not the day to do that.
I just wanted to state one thing. That's all.
I don't know, Ms. Cusson, if you want to tell him not to state anything.
Mr. Vance, I'm emailing your attorney on your out on bond case, so they know that you're in jail. Did you have a question about your bond, your release conditions?
No, I can bond out though now, right?
Yes.
Okay,
Yeah,
that's fine.
I did not revoke your release.
I was just asking if you could please, ma'am, consider that to ROR because I had to go to the hospital. They took me to the hospital. That's the only reason I was driving. I have a huge cut on my leg.
I'm not gonna. Well, you just admitted to driving. So
I know.
now
I had nobody to drive me.
The more you talk, the more it's not good for you.
Okay.
So I'm not gonna ROR you. You have an active warrant out of another state. So and I'm not. You have an out on release case for grand theft, petty theft, and possession of drug paraphernalia, and now you've committed or alleged to have committed a new law offense that you've now admitted to. So I'm not going to ROR you. You have 9 failures to appear, the last being in August of 2019. Okay?
All right.
All right. Please tell me your name.
Nicholas Ward.
Mr. Ward, you're here in 2020 CF 771080. You're arrested for possession of fentanyl and possession of drug paraphernalia. Do find probable cause, and I'll appoint the public defender. No drugs or alcohol without a valid prescription. Mr. Ward, where do you live?
Orlando.
Do you live with family or?
I'm homeless.
Okay. Do you have an address that you get mail at?
Yeah.
Okay. And is that the 9448 First Avenue?
Yes, ma'am.
Okay, so you'll get your mail there?
Yeah.
Okay. So it's very important. I'm going to release you on your own recognizance on both accounts. You need to make sure that the public defender is able to get in touch with you. If you move or that's a different address that you get your mail at, you need to let the clerk's office know and the public defender. Or else if you miss a court date, you can probably get a no bond warrant, all right?
Okay.
Okay. Who was that? What was her name on that? All right, good afternoon. Tell me your name.
Stephen Watts, Jr.
All right, Mr. Watts, you're here in 2019 CF 16888AO. It's a failure to appear for your trial on June 17th, 2020.
Yes, ma'am. I'm sorry. I was dealing with the death of my son.
I'm sorry to hear that.
Yes, ma'am. Yes, ma'am.
You do have a bond, okay? So the judge did give you a bond. I can't change that. So it's a $2,500 bond. Are you, well, it's Division 22 is Judge LeBlanc. Did you miss it because of the death or
Yes,
because
ma'am.
you didn't get notice or what?
No, I was dealing with my son. Like I told you, he passed away in his sleep, and I wasn't even myself for like a week or two. I was just in a dark place, just not eating and nothing. I'm sorry about that.
Okay. Well, I'm not the trial judge, okay? So, but Judge LeBlanc did give you a bond. Are you able to afford a $2,500 bond?
Is there any way I can get it lowered, ma'am?
Well, my question was, can you afford it?
If it gets lowered a little bit, I can.
Okay, what
Yes.
kind of bond can you afford?
150 or lower, I can do.
Okay, so I will reduce the bond to $1,500. I'm not going to take any action on the out on release case. Make sure you don't miss court, or you know where you need to be for court.
Okay.
Do you have do you have an address
Yes, ma'am.
that you can write down?
Yes, ma'am.
Okay. Do we have the change of address forms over there at all, or a piece of paper he can write his address on?
No, Your Honor.
No. Okay. Well, can you say it as loudly and slowly as possible?
Okay. It's 231 North Cottage Hill Road, Orlando, Florida, 32805.
Cottage Hill Road.
Yes, ma'am.
Okay. So that's what I'm going to give the clerk to put in for the records, because I don't know if we have your address or not, correct? So I think on the KPS it says 2803 West Arlington Street. So you're not there anymore?
No, ma'am.
It's really important that if you move, or you know, that you keep in touch with the attorney, you tell them where you're living in the clerk's office, because if you miss court again, you may not get a bond, okay?
Okay, thank you.
Okay. All right, and just for the record, I did have permission from Judge LeBlanc to change any KPSs that may come in within my discretion from his division, as well as Judge Marquez. All right, please tell me your name.
Antonio Williams, ma'am.
All right, Mr. Williams, you're here in 2020 CF 5332AO. You're arrested pursuant to a warrant. There's 3 counts on the warrant for sale and delivery of cocaine, sale and delivery of cocaine within 1,000 feet of a child care facility, and then possession of cocaine. The state only filed on delivery of cocaine, a controlled substance within 1,000 feet of a child care facility. So what I'm going to do is ROR on count 1. Count 2, I'm going to set at, I think that it came in at the 10,000. So I'll set that at the 10,000, and count 3, I'll ROR on that. No drugs or alcohol without a valid prescription, and no return back to the scene of where the offense is alleged to have occurred.
Yes,
And
ma'am.
I'm not going to take any action on your other case, so make sure you don't miss court. Keep in touch with your attorney, okay?
Your
Yes,
Honor,
ma'am.
as for
Hold on one second, Mr.
2020
Williams.
CF 5332, it looks like they only filed on count 1.
Well, they filed on, it's count 2 and the,
That's what, okay, that's.
yeah, so
makes
I
sense.
ROR'd on count 1.
and then
I switched the
10,000.
bond, and then ROR'd on 3.
Great.
Okay.
And Your Honor, we did add another fed. That's no action on that one as well.
Huh?
We added another FAT this afternoon. Is that no action on that FAT?
Yeah, I'm
as
not
well?
taking action on, I don't have it, but, oh, I see it on the thing. No, I'm not gonna take action on that. Mr. Williams, listen to me carefully. You've got 3 cases, 2 sale and deliveries, and then possession. So, things aren't gonna be a good day for you when you come back, if you come back again with another new law violation, okay?
Yes, ma'am.
All right, so keep it clean.
Have a blessed day.
All right, you too. Okay. All right, please tell me your name.
My name is Scott Allen Beer, Your Honor. Thank you.
Mr. Pieper?
Yes, ma'am.
Okay. All right, you're here in 2016 CF 16074AO, and it's a violation of probation warrant, and the judge did set the bond at none. I am going to appoint the public defender. And so you'll see Judge Whitehead in a couple days for your arraignment. In the meantime, the public defender's office, you'll have to contact them. They can file any motions to set bond for you, okay?
I couldn't hear, could you say about the bond, please? What did you say?
Your bond is set at none.
Is that
So
what?
it's set at 0.
Okay.
So I have appointed the public defender. You will see Judge Whitehead for your arraignment in a couple of days. And the PD can file any motions to set bond for you, okay?
So what will happen today? I understand,
We
you said the
d-
bond's
we-
at 0.
Yes, your bond is at 0
So I have
on
no
the
bond-
warrant on the VOP. I'm not changing Judge Young's bond,
So I have no bond at all.
correct?
Okay.
Okay? You'll see Judge Whitehead in a couple days. Maybe that will change. I don't know, okay?
Thank you.
All right.
Your Honor, next on the list, Michael Bridges, medical.
Okay, so here, it's a couple cases. They're drug court, VOP, on views. I'll appoint the public defender in 19 CF 1674 and then 18 CF 2483 AO. And Ms. Custon, do you want to waive?
Yes, Your Honor.
All right, so there's on view VOPs. I do find that there's probable cause based on the affidavit. The bonds will stay set at none, and he'll see Judge Whitehead in a couple days for his arraignment.
Next we have Naran Gopal, medical.
Medical,
Yes.
all right. So that's 2016 CF 6641 AO, and it's a violation of probation warrant, and I'll appoint the public defender. Ms. Custon, do you want to waive?
Yes, Your Honor.
All right, so Judge O'Kane set the bond at none. That will remain set at none. And I'll take no action on the out on release case.
Your Honor, I can't tell if we're appointed on the out on release case quite yet.
Let's see. Nope, we'll appoint you.
Thank you.
Yeah, he bonded before IA. Thank you. All right. All right, sir, tell me your name, please.
Julio Guaramud.
All right, Mr. Guatemala, you're here in 2018 CF 13378 AO, and this is a violation of probation warrant. And the judge in your case did set your bond at none. And I'll appoint the public defender. You'll see Judge Whitehead in a couple days for your arraignment. But the public defender's office can file any motions to set bond for you, okay?
All right.
Not going to change the warrant, yeah.
I have a question. All right. My warrant was for the drug treatment and my payment. I did complete all of this, so I was wondering.
Well, you're going to see Judge Whitehead in a couple days.
Okay.
So you can provide that information to Judge Whitehead and also contact the public defender.
Okay.
And you can call them, and then you can tell them any documentation that you may have. And I don't know if Ms. Custon can get that, or I don't know. But it depends. I think it's going to depend on when you completed that and whether or not the judge finds that you completed it. So.
All right. Yeah, the probation officer does have that information. I emailed it over to them, so they should have it.
Well, all right, but this warrant was signed back at the end of May, so I don't know what information that they had at that time. So it's just important that you call the public defender's office and let them know about the documentation.
Okay.
Okay?
All right.
All right. All right, good afternoon. Tell me your name.
Eric Michael Ganesh.
All right, Mr. Ganesh, you're here in 2018 CF 12449 AO, and it's a violation of probation, and the judge did set the bond at none. And I'll appoint the public defender to represent you. You'll see Judge Whitehead in a couple days for your arraignment. And the PD's office can file any appropriate motions to set bond for you, okay?
Okay, could I
All right.
let one thing for the record, Your Honor?
Just be careful what you say. I don't want you to say anything about the violation or whether or not you've
Oh, okay, so.
done it or not. So
All
I
right,
mean,
so they're
everything
gonna
that you say is being recorded.
Right, I was just gonna, okay, so I'm gonna see Judge Whitehead in a couple days, and we'll be able to
Yes.
resolve this then?
You may be able to resolve it. I'm not sure. It's just going to depend on Judge Whitehead and his setup and if he can take pleas or whatnot. But something may be able to get resolved at some point. soon,
Okay.
Okay.
All right,
I just
thank
can't
you.
do it today. All right.
Understandable.
All right. Thank you,
All right.
Mr. Ganesh.
All right,
Good
thank
luck.
you.
All right.
You're on the next on the list, Miles Pennant. He's medical.
He's what?
He's medical.
Okay. All right, so Mr. Pennon is medical. I'm gonna appoint the public defender. It's a couple of on-view violations of probation. Ms. Cussin, do you want to waive?
Yes, Your Honor.
Okay, so 2019 CF 13410 AO, 2019 CF 8100. Is that DO? Okay, DO, and then 2019 CF 5642 AO. There's only three, right? Yeah. Okay. So there is probable cause for the on-view violations of probation based on the new law offense of robbery with a firearm. And I'll appoint the public defender on all three of the cases, and he'll see Judge Whitehead for his arraignment. Okay. All right, good afternoon. Tell me your name.
Harry Kennan Elliott.
All right, Mr. Elliott, you're here on a Marion County warrant, or it's a violation of probation.
Yes, ma'am.
Yeah, so Marion County set your bond at none. So what I'm going to do is here, we're going to appoint the public defender for you here. And one of the judges here in Orange County is going to contact the judge in Marion County to see if they'll be amenable to giving you a bond or some sort of other release.
Yeah.
But I can't change that today, okay?
Okay, ma'am, they offered 90 days. I already have a
I can't, there's nothing that I can do with your case. It's a Marion County case.
This is the one that we had agreed to.
Oh.
Mr.
been here 50
Elliott.
days.
Oh, they brought, okay.
I don't have the VOP. If there's an admission in there, I can just go do it real quick because they sent it to me.
I'm sorry. We were supposed to have you on the docket this morning, and
Yes,
then
ma'am.
somehow it got mixed up. So
Yes, because then we can just get it done with.
I have 90 days served on the VOP.
no, yeah. Well,
84.
you have 83, and then tomorrow, yeah, you have 83 days, and the offer was 90 days.
Okay,
so it would
that's
be a
fine.
couple more. It would be. You might get the game time. I don't know.
Yes. I should
So
have
hold on
game
one
time.
second. Hold on, Mr. Elliott.
Yes, ma'am.
The public defender is going to go get some paperwork so that we can get this plea done for you. Okay.
Thank you. Thank you very much.
Okay. We reset you for tomorrow because we didn't think that you were coming today.
No, I've been downstairs since 7:30 this morning, ma'am.
Oh wow. I'm
Yes, ma'am.
sorry.
They missed me down there somehow. It's an accident in the paperwork, I guess. Now, I would state that the only reason I really violated was because I couldn't pay the tickets on 413 because the courthouses in Lake County were closed. That
Okay.
created a technical. I'm gonna be a. Oops.
And Your Honor, since these are out of county cases, I know we're going to be appointed, so you could continue while I, if you would like to.
Well, you were already appointed when he came in.
I meant the other people, but
Well, we have to call attorneys for those cases.
Okay. I'll be right back.
Let me pull up the paperwork. Because I brought it back to my office.
Yeah.
Arlene, do you need me to forward it to you, print? For the VOP?
What are you forming me?
The VOP documentation for this plea?
Same thing we had on there this morning?
Yeah.
No.
Oh, okay.
She's gonna put it back in the hopper, so I guess I'm gonna use that same one.
He's like, we worked it out. Well, that's good. So, I don't think Judge Johnson will have to deal with it tomorrow. And Ms. Custon, do you need the case number to put on the plea form?
Yes, Your Honor.
It's 42-2019-MM-004525, and it's Marion County.
And Your Honor, there was the new law, but the 33-day motion was granted this morning.
I'm sorry, you're gonna have to get a little closer to the microphone.
There was the new law violation, but the 33-day motion was granted today, so this is the only thing holding him now.
Would that be correct? If he pleads to this, then he was ROR, Courtney,
He was RR on the
new law?
driver while suspended license.
Yes.
I think,
I only see that they have processed the motor vehicle. Maybe they're still working on it for the duelist.
well, according to my order, that would be released today on the ROR for that one. So they may be processing it. And so, Mr. Elliott,
Yes,
the
ma'am.
violation of probation alleges that you absconded from supervision by missing appointments on January 7th, 2020, January 24th, 2020, and February 7th, 2020. And that's a violation of condition 2. And then you also have a violation of condition 8, which was failing to pay the cost of supervision, and that your cost of supervision is still $420 that you're in arrears, meaning
Yes,
you
ma'am.
still owe that amount, okay?
Yes, ma'am.
So what I'm gonna do is did you read that plea form?
Yes, ma'am.
Okay, and did you understand everything on the plea form?
Yes, ma'am.
And have you had an opportunity to talk with anybody about the plea?
Yes, ma'am.
Okay. And so you understand all those rights that you're giving up by entering the admission to the violation of probation?
Yes, ma'am. Yes, ma'am, I do.
Okay. And I'm just going to pull up the notes. From the docket. So, so Judge Williams, who I guess is the judge in Marion County, has said that he's going to revoke and terminate the probation, which is what we're going to do today. You'll serve 90 days in jail. You already have 32 days on the underlying offense in Marion County. And then you've been incarcerated here in Orange County since May 4th, 2020. So as of today, in Orange County, that is total altogether 83 days.
What about gain time?
I don't know, but my guess is you will get the gain time. Ms. Custon may be able to know more about that, but my guess is that you'll probably get that gain time. Okay?
Yes, ma'am.
All right, so obviously I know that you are on probation and you're admitting to the violations of probation. Do you understand that if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am. I'm a U.S.
All right.
citizen.
Okay, I do find a factual basis based on the affidavit of violation of probation to accept your admission to the violation. I am going to revoke and terminate your probation, sentence you to 90 days with credit for 83 days time served. I'm ordering that all of the monies that you still owe, any of the court costs and any of the cost of supervision, that you pay those. Do you want to start paying them? Do you want a monthly payment, or do you want me to just give you a year to pay it?
I need a year to pay it.
Okay, so I'll order, and you'll probably have to get with Marion County Clerk to find out about the payment, but I'll give you a year to pay. You'll be paying, make sure you pay by June 23rd, 2021.
Okay, do I pay
Okay.
Orange County or Marion County?
You would pay Marion County.
Okay.
Okay, so call the clerk's office when you get out and find out when, who you make those payments to.
Okay, and it's $400?
Well, you're in arrears $420, but I don't know if you have other costs that you still are paying on the underlying case, okay? So you'll have to
Okay.
get with the clerk in Marion County to find out how much you owe, okay?
Okay.
All right, if you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you.
No, ma'am, I'm good. Thank you.
Just in the future.
Yep. There is no future.
I'm gonna go.
Your Honor, next on the list is Darian Kelly, Hospital. Can't hear you. Can you hear me? No. I can't hear. Uh-oh. Get a reboot. Okay. Yeah, that's a reboot, so.
And my attorney is not going to be present.
Your attorney is who?
Isabel.
Oh, I don't know.
I spoke to her this morning. She said she was planning on getting the court.
Oh,
Well, they'll know you got an attorney.
yeah.
But you can tell her that you got a private attorney.
She should have spoke to her already.
Can't hear you. No wonder he was fixing on this thing early in the morning. Almost finished. Yep. One, two. Yeah. She know. Yeah. Can't hear. Nope.
You know, I never had a toothache. Well,
That's the worst thing in the world.
but my brother them had it.
It gives you your ear.
Here,
Yeah.
all the way up here.
Yeah.
Migraine, animal saw.
Then as soon as you get to sleep, the alarm clock will walk
Yeah.
through.
Never had a toothache.
It hurts. It hurts. And then if you lag it, it's swollen to your eye.
Again, it don't help that you gotta have this mask.
Right, it keeps the bacteria in the mouth. Because my attorney said that she was trying to get us on 0 bonds.
Where you from? Cause you have a accent.
Oh, I'm from Canada originally.
Oh, okay. Right here.
Oh,
Where
you
you want from here?
Yeah. I've been here for a long time.
It's still in you. I said, I know you're not from here, cause I'm country. And you don't sound like me.
You're country. I like country music.
Uh-oh. It's gonna be a long time. It's gonna take a while. It's gonna take a while.
So can I call my attorney, see if she's gonna be present? I can.
What can you call them?
I could call my daughter to let her know.
Well,
Maybe you have a phone?
female to be on, or like, they mess around and jumped on cases.
She's way man.
Yeah. Nothing.
You wanna walk over?
Oh, she's here?
Oh, not hers. Yeah. Well, had a couple people.
Yes. So disconnect from both courtrooms and,
We hear you. Hey,
can you all hear me now?
yes, ma'am.
Yes?
Yes.
Yes.
Okay, they can hear me now. What happened?
The country that controls the audio system in courtroom 2, somebody interacted with it in terms of the system.
Oh, somebody in courtroom 2.
No.
We don't touch anything.
They didn't touch anything.
No.
They're saying nobody touched anything.
We don't even bother anything.
I don't know, they're denying.
Okay, well,
I'm on the oath too. I'm on the
I
oath.
figured
All
they-
right.
they was gonna put it
They're
on
under,
correction.
they're all under oath.
Yeah.
Okay, thank you, Paul. Okay, bye.
Your Honor, Darian
Okay.
Kelly is hospital.
Okay, yeah, we're gonna have to call the Kellys because we have an attorney that we're going to call. So I'm gonna address them at the end when we call the attorney. Okay?
Miss Kelly here, okay.
Yeah, but I'm gonna call her at the end and then we'll address both of those cases. Okay? Okay, and then.
No, they're gonna put her at the end, she's gonna go last. Martina?
All right, good afternoon. Tell me your name.
Melissa Martinez.
All right, Miss Martinez, you're here on an Osceola County warrant, and the judge did set your bond on count 1 at $5,000 and count 2 at $2,000. I'm going to appoint the public defender here to represent you. And if you're not able to bond out, regardless, one of the judges here will reach out to the judge in Osceola County to see if they'll reduce your bond. But if you are able to bond out, you can bond out. If not, you'll be back on the docket probably in a couple days for a status hearing, okay? Okay, thank you. All right, good afternoon. Tell me your name.
Javier Torres.
All right, Mr. Torres, you're here on a Seminole County warrant, and it looks like it's a no bond warrant. So I'm going to appoint the public defender here to represent you. One of the judges here will get in touch with the judge in Seminole County to see if they will give you a bond or release you in some other manner. So hang tight, but you'll probably be back on the docket in a couple days for a status hearing, okay?
Okay.
All right, is this Mr. Who is this?
This is David Okino, ma'am?
Okay, Mr. Okino.
Yes, ma'am.
Okay, hold on one second. So, Ms. Fusco, I did get an email. I believe Ms. Custon was copied on it as well. I'm not familiar with this case, so I will have to read it to see if it's applicable. I don't know if I've ever read this case. I got it.
Yeah. Have you all read the case? It's not that long. I don't know. Ms. Custon, were you able to read it?
The 9-page one? I think it's the same. Oh, the case.
The case that Ms. Bush
For
emailed?
PC.
It's Davis v. Jr., which doesn't appear to be a final case, but it's a third DCA case. 2020 Westlaw 808702. And it's dealing with probable cause, but at a adversarial preliminary hearing. So for Mr. Ochino's case, we've got 2020 CF 765380. He was arrested for robbery with a deadly weapon and aggravated battery with a weapon. I reset the case yesterday for the state to, for 24 hours to submit to supplemental information as to counts 1 and 2 for probable cause. They provided the court with additional supplemental information, which does support the probable cause, but it's not sworn to. And they provided the court with this case. To say that I can find the probable cause. Without it being sworn to. Where's my rule book? So, Ms. Fusco, please explain to me why I can rely on this case when the initial documentation that I was provided did not provide me with the probable cause or any probable cause. So, according to what Ms. Bush sent, and I guess that you're going to argue, I'm not really sure. If there's nothing that's in the first affidavit that I can rely on for probable cause, how can I rely on non-sworn testimony to make a probable cause finding? I think that I don't see how this case works for me.
I think the argument that Ms. Bush was submitting was that hearsay is allowed, it just can't be the sole basis of probable cause.
Right, but there's nothing in the first affidavit that's sworn to that meets any of the elements of those two offenses.
I think you do need the second supplement to get.
I think you need the jurats, and if the state is I don't know what you're asking for, but 3.133 provides for additional time if you are asking the court to give you additional time, because I understand that you've made the good faith effort to get it, and you did provide it to me, and you're making the good faith effort to try to get the jurat. I'm not sure how it can't just be scanned and emailed like any other document.
Apparently it was accidentally sent in interoffice mail.
Well,
and it hasn't arrived.
And Ms. Bush's email says that OCSO has diligently attempted to get additional jurats because they are not computer-generated documents. They're processed by a different department, and they want, the state's asking me to rely on these non-sworn incident reports. Ms. Peston, do you want to be heard?
Your Honor, we argue that they're not asking for additional time, and they're asking it to be relied on something that is not going to get us to where we need to be. So we're asking that at this point, the judge makes a finding, makes a ruling, and doesn't find probable cause on those two charges.
I would just like to say in the alternative, Your Honor, if you can't consider some hearsay testimony with the non-sworn supplement that asks, since we have done due diligence, to give us additional time to get the jurats.
Are you getting the, are you intending to, I mean, somebody's gonna have to hand deliver them.
Right.
Because if it's not by tomorrow, then they're gonna be released.
Okay.
Unless you file some other type of motion.
Okay, Your
But
Honor.
I feel like the state's made a good faith effort. They have the information. I've been provided it. They're missing the jurat. I understand your argument, Ms. Cusson, and I completely agree with you. And it's not that I am refusing to rely on the supplemental reports as not as hearsay. I mean, they are hearsay because they're not sworn to, but there's nothing in the original incident report that was sworn to that adds any, I mean, it doesn't add anything. So it's just talking about everything after the incident and how they arrested the defendants. It doesn't talk about the charges, what, you know, the elements of the offense. So I don't believe that this case is applicable in this circumstance, because if it were just supplemental information, and we're also at a completely different type of hearing, even though it is a probable cause issue. But I will give the state the additional 24 hours. That's it. That's all you all get. And so if you don't have the information by tomorrow, then unless you file some other type of motions, but I don't believe that I can rely on this case for purposes of the probable cause. Because I'm rereading the original arrest affidavit, and it doesn't talk about, it just says, just keeps referencing a robbery, but it doesn't talk about any facts or any identification or anything of that nature. So, okay. So, Mr. Ochino, I know that it's frustrating, but I'm going to have to reset your case for tomorrow. To give this, the state did provide me the documentation that I needed, but it has to be sworn to, and somehow that sworn piece of paper that an officer swears to didn't make it to me, and I need that.
To be honest, it was never sworn. They never
Well,
sworn.
no, the officer swears to it when they write the report. So, and I have no reason to believe that they don't have a jurat. It's just missing in action. So, Mr. Ochino, I am going to reset you for tomorrow again to address both counts. And pursuant to Rule 3.133, the state will get the additional 24 hours, as it is a good faith reason to do so. And so do we have Mr. Meadows as well?
He's behavior, Your Honor.
Okay. So, all right, Mr. Ochino, I won't be here tomorrow, but another judge will see you tomorrow, and I'll explain everything to him, okay?
So it'll be explained how you.
Yeah, if the state doesn't provide the sworn affidavit from law enforcement, then he'll address whatever he needs to address. The state could still file other motions, but I don't know if they would. Okay?
Yes, ma'am. Thank you.
Okay. I apologize.
That's okay, ma'am.
And then Mr. Meadows, so we'll reset for tomorrow. Let me write these case numbers down so I can talk to him. Oh, I can? Mm-hmm. Okay, I'll leave these for Dave. Okay. All right, and then Mr. Meadows' behavior, and so that's 2020 CF 7654AO. And again, the state provided the additional supplemental information, which does provide the court with probable cause, but it's not sworn to. They've indicated that the affidavit, or excuse me, the jurats are en route, but have been misplaced. And I'm not relying on Davis v. Jr. to find probable cause. I don't think it's applicable in this situation based on the original affidavit, which provides no information to me as to the charges. So, Ms. Fusco, are you asking the court for anything?
Just the additional 24 hours, Your Honor.
Okay. And so based on, I believe that there's a good faith basis, and I know, Ms. Custon, you're objecting to that.
Yes, Your Honor.
And it's noted for the record, but I will, pursuant to 3.133, allow the state the additional 24 hours to provide the jurat, and I will advise Judge Johnson so he knows about the two cases. Okay. And now we have to call Giselle Villar. Do you have the phone number? And you said Mr. Kelly was in the hospital?
Yes, Your Honor.
Okay. And this is Melissa Kelly?
Yes, Your Honor.
Okay. All right, good afternoon. This is Judge Wish. Who am I speaking with?
Good afternoon, Your Honor. This is Attorney Annabelle Nahra from Jeff Wiener's office.
Okay. Miss Nahra?
Nahra, yes.
Nahra, okay. I understand, are you representing Melissa Kelly and Darian Kelly?
Yes, we are.
Okay, and you filed notices of appearances in St. Lucie County for them?
We have, yes.
Okay. I have Melissa Kelly before me. It appears as though Darian Kelly is in the hospital.
We've been advised, yes.
Okay, I just wanted you to know that he's not
Thank you
present
so much,
in the courtroom. Normally, what we would do on the out-of-county cases, because they're not transporting people, if they're not able to post their bonds, we appoint the PD here, and they, one of the judges here, pursuant to the Florida Supreme Court order, contacts the original jurisdiction and asks to see if they will modify the bonds, because we can't modify the bonds on our own.
I understand that.
So I won't appoint the public defender here because you're indicating that you're representing the both of them?
That's correct, yes,
Okay.
Your Honor.
So Melissa Kelly is before me, and so she was arrested for a St. Lucie County warrant. Her bonds are set at $10,000, $20,000, and $25,000. And so, since they're not transporting people, Ms. Nahra, do you know if they're able to bond out?
So we have a bondsman that's ready and in place to be able to bond them out. We were hoping to be able to get the bond reduced.
I can't do that, yeah.
I understand that. We've reached out to Judge Belanger's chambers, who is the judge, the circuit court judge assigned to the Port St. Lucie case, and we've been trying to get a bond hearing in front of him set for today. Unfortunately, he's got a very full calendar, so we're trying to make that happen today, but from what I'm hearing from you, you wouldn't be able to modify the bond anyway, but are you able to keep the bonds as they are? And if so, would Mr. and Mrs. Kelly be able to post the bonds?
Yes, they can post the bond at any time. I don't believe there's anything else holding them, correct? No. So they have no other holds. They would be able to post the bond and they would get released. You can... we have Judge Amy Carter is the judge here in Orange County that works with the judges in the other counties. And so she would be the one that would communicate with the other judge in St. Lucie. You may want to let the judge there know that, because she'll probably end up reaching out to him if they haven't bonded out.
Right.
But you also can, if he can't have a bond motion because the defendants are not present there, you can always file a bond motion here in Orange County. And Judge Letitia Marquez is the judge, is the administrative judge in criminal circuit. That would be the one that would hear the bond motion here.
So I appreciate the information, your help, Your Honor. We did try to do that this morning, but we were advised by Judge Marquez's JA that she wouldn't be able to hear the bond hearing until Thursday.
Okay.
And obviously, we were doing everything we can to try and get our clients out today.
Right.
So if Your Honor goes ahead and lists the bonds as they are, we will try and see if we can get a bondsman to post the bond. If the bondsman is able to post the bond in Orange County, both Mr. and Mrs. Kelly should be released, correct?
Yes.
If in the meantime I'm able to convince Judge Belanger to hear us on his calendar this afternoon, I might be able to reduce the bonds and then have that information communicated over to the jails and then try to get them bonded out.
Yes, that would be the other option.
Wonderful.
Okay.
Okay, so we're going to have option A and B. Thank you so much, Your Honor.
So for Mr. Kelly, Darian Kelly, that's a St. Lucie County warrant too. His bonds are $15,000, $20,000, and $25,000, and he was in the hospital.
Yes.
So do you want to waive his appearance, and we'll just
Please, yes.
Okay. So we'll waive his appearance from the attorney on the phone, and the bonds will stay the same. And in the meantime, I guess you're going to be working to get them bonded out or reduction of bonds.
We are, yes.
Okay. Anything further?
Nothing further from me, Your Honor. Thank you so much and have a good day.
No problem. Thank you so much. Have a good day.
Thank you.
Okay.
You too.
Bye-bye.
Bye.
All right. Thank you. And so, Ms. Kelly, it sounds like your attorney's working on your behalf, so you should find out some information soon, okay?
Okay, thank you, Your Honor.
All right. Thank you. Okay. All right. Anything else? No? Okay. Anything over there? No?
That's it.
All right. Hanging up.
All right, let's go ahead and swear the defendant in.
You raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Good morning, ma'am. Tell me your name and your date of birth.
Misty White, 10/25/1985.
Ms. White, you have two matters before the court this morning. The first is felony case 19 CF 4223. In that case, you're charged with aggravated battery with a deadly weapon, an act of domestic violence, a second-degree felony, punishable up to 15 years in prison. You also have misdemeanor case 2020 MM 581, the offense of violation of pretrial release condition on a domestic violence case, a first-degree misdemeanor, punishable up to a year in a county jail. We were supposed to resolve your case yesterday, but we were advised that you are under quarantine because someone at the jail that you had contact with has tested positive for coronavirus. So we reset you for today. Your attorney on your felony case, Mr. Consalo, is present in the courtroom, and the public defender's office advised me that you also want to resolve your misdemeanor case yesterday and explain that to me. So I was going to proceed with your plea. Are you okay with that, ma'am?
Yes, sir.
All right. Mr. Consalo, how does she want to resolve the case today?
Yes, Your Honor. In case number CF 19-4223, today Ms. White's going to withdraw her previously entered plea of not guilty. She's going to be entering a plea of no contest as charged to aggravated battery with a deadly weapon, a violation of Florida Statute 784.045. In exchange for such a plea, the state's willing to offer the following recommendation to the court. There would be an adjudication of guilt, 90 days in the Osceola County Jail. She has credit for 134 days time served, followed by 48 months of probation. She would do a batterer's intervention program. She would have a mental health evaluation. She would have a substance abuse evaluation. She would do 100 hours of community service. She would possess no weapons or firearms whatsoever. She would take no drugs or alcohol while on probation. I think she is pregnant right now, so she may have to take drugs for the pregnancy, so I'm hoping the state means no drugs without a prescription. Restitution would be ordered, reserving as to the amount. There would be court costs, costs of prosecution. Additionally, contact was to be determined based upon the victim's testimony in this case. You may recall the victim did appear yesterday. He did testify under oath to both direct and cross-examination by the defense and the state that he was willing to have no hostile contact with the victim as opposed to no contact, and he was okay for her to return to their home. He is the father of the child that she is currently carrying. I have gone over a plea form in its entirety with Ms. White. She has signed it, as have I. May I approach, please?
Ms. Gonzalez, is this your agreement?
Yes, Your Honor. I'm not sure if I heard him also indicate a mental health evaluation, substance abuse evaluation.
I'm sorry, I didn't hear it.
Ms. Gonzalez did not hear you recite that there would be a mental health evaluation and a substance abuse evaluation as part of probation.
Yes, Your Honor, and I'm sure it's because of the mass. I did cite that on the record. It is also on the plea form, Ms. Gonzalez.
All right.
And the only thing I would note on the plea form, Judge, I don't know if you actually came to a ruling yesterday on the contact, so I would just, the plea form could read contact in the discretion of the judge or something like that.
What I wrote on the plea form, Ms. Gonzalez, was that contact and return to the home would be determined at a hearing at sentencing.
Okay. Perfect. All right. So my question is it 90 days, is it time served followed by 48 months of probation or time served as a condition of the 48 months of probation?
I would ask Ms. Gonzalez what.
Time served followed by 48 months.
Okay.
Probation.
All right. Ms. White, is this how you want to resolve both cases?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
No.
Do you read and understand the English language?
Yes.
Your attorney has given me a document called a plea form. I'm holding it up. It's a 4-page document. It's got your name on it. It's got your case number on it. It's got the charge you're pleading to, the resolution, and all of your rights. Did you go over that form?
Yes, sir.
Did you read all of the form?
Yes, sir.
Did you have an opportunity to discuss with Mr. Consolo all the rights you have and the rights you're giving up by entering this plea today?
Yes, sir.
Did you answer any questions about, or did he answer any questions about your rights? Did you then initial each paragraph indicating that you read and understood what was explained in that particular paragraph?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Did you also go over a plea form in your misdemeanor case with the public defenders?
I didn't go over the plea form with the public defender, but I've already seen it.
Okay. Do you understand that you have all of the same rights in that misdemeanor case that you went over in your felony case?
Yes, sir.
And do you understand you're giving those rights up as well when you enter this plea today?
Yes, sir.
All right. Has anyone forced, threatened, or coerced you to enter each of these pleas?
No.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive?
No.
Judge, may I interrupt? I did want to clarify the record. My understanding from Ms. Gonzalez is that the offer for the misdemeanor would be global, and it would be credit time served on the misdemeanor. Even though I was not the attorney for Ms. White, I did explain that that would be one of the promises that the state had indicated in order to enter this plea.
Okay. Ms. Gonzalez, is that correct?
That is correct, Your Honor.
All right. And this is a departure sentence, correct?
Yes, Your Honor.
It is, Your Honor.
All right. At the appropriate time, I'll give you a chance to make a record on that, Ms. Gonzalez.
Thank you.
So again, Ms. White, other than what's been discussed here in court, has anyone made any other promises to you about the sentence you would receive?
No.
Are you satisfied with the work that Mr. Consolo has done in handling your case?
Yes, sir.
Are you satisfied with the work the public defenders have done on their case?
Yes, sir.
Do you understand, ma'am, if you were not a citizen of the United States, entry of these pleas would result in your deportation?
Yes.
One other thing I want to take a moment and talk to you about, ma'am, you're getting a departure sentence. You're going to be on probation. If you violate probation because of the charge you're on, you would be classified as a violent felony offender of special concern. What that means is you couldn't get a bond on a VOP absent something called a danger hearing. And you should be concerned if you violate your probation, you may not be able to convince the state or the court to give you another departure sentence. So you could be going to prison for a good long time if you violate your probation. Do you understand that? All right. And again, ma'am, do you understand if you're not a citizen of the United States, entry of this plea would result in your deportation? Yes. Ms. Gonzalez, factual basis for each of the two cases?
Yes, Your Honor. In 2019, CF 4223, on or about December 14, 2019, the defendant and the victim, Mr. Miguel Sanabria, are in a relationship living together. They were arguing about money at the time. Victim began to gather his things to leave, at which point the defendant came into the bedroom with a glass coffee pot and hit him on the back of the head, causing a very large laceration and blood loss. The victim was then transported to Celebration Hospital for treatment. Law enforcement did observe large pieces of broken glass scattered across the floor in the bedroom. All of that occurred in Osceola County, Florida. In reference to the misdemeanor 2020 MM581, on or about February 28th, 2020, a call to 911 stated that defendant and the victim were arguing, and she wasn't letting him leave. The victim himself called 911. Upon law enforcement arriving, he saw them arguing and he observed them together. He did note that there was a no contact order for 2019 CF 4223, where defendant is not to have any contact with the victim or be within 500 feet from their location, and all of that occurred in Osceola County, Florida as well.
Any objection to that factual basis for purposes of this plea, Mr. Consalo?
Yes, sir.
Mr. Carbone?
No, Your Honor.
Ma'am, I'm going to accept each of your pleas. I find you alert and intelligent. Your pleas are freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of each plea based on the presentation in court and the affidavits filed in each case. Mr. Consalo, is there any legal reason why sentence should not be imposed?
No, sir.
Mr. Carbone? Ms. Gonzalez, anything you want to put on the record in regards to the decision to enter a departure sentence?
Briefly, Your Honor, the defendant has no prior convictions. There are some previous batteries on her record, but they weren't charged and they're not with the same victim. They're from years ago. During the entire case, the victim was himself uncooperative, though I did have enough to go forward without him, in addition to the fact that the defendant is pregnant. That was all part of my decision to give her the 48-month probation.
All right, before I impose sentence, the only other question I have for the lawyers is she's currently on quarantine inside the Osceola County Jail because of a contact with someone who's tested positive for coronavirus. Typically, I would order her to report to Department of Corrections probation within 2 days of her release. I suspect they would not be very happy with me under the circumstances if I ordered her to go over. Does anyone know how successful defendants are in connecting with Department of Corrections via phone at this point?
I don't, Judge. The only suggestion I would imagine is if she is released today, she probably needs to self-quarantine for 14 days. So my suggestion would be to allow her to report to probation within 16 days or something like that, so long as she is not exhibiting any signs of COVID.
Okay. Ms. White, you're going to need to listen very carefully when I get to the probation part of this sentence. So we'll start with the easy part. In 2020, MM581, I'll adjudicate you guilty. I'll sentence you to 117 days in the Osceola County Jail with credit for 117 days time served. I'll order you pay whatever statutory required fines, fees, and costs are associated with that case. In case number CF 194223, I'll adjudicate you guilty. I will sentence you to 134 days in the Osceola County Jail with credit for 134 days time served. That's going to be followed by 48 months of supervised probation through the Department of Corrections probation site. Now, this is where I want you to listen carefully. I'm going to order within 2 days of your release from custody that you contact Department of Corrections Probation either by telephone or by email and indicate that you're required to report, but also indicate that you are on quarantine in the Osceola County Jail due to exposure to coronavirus. And I want you to follow their instructions on when they want you to report in person. Do you understand me, ma'am?
Yes, sir.
I will order under any event, if they don't answer the phone and you can't get through to anyone, that you report to Department of Corrections Probation no later than, and I'm going to give you a date, Wednesday, July 8th, 2020. Okay, so if they don't pick the phone up, they don't respond to an email, you need to make sure you report no later than July 8th, 2020. Now, if you get diagnosed with coronavirus, then you need to contact Mr. Consalo and or Mr. Carbone from the Public Defender's Office and say, what do I do now? And they'll bring it to my attention and we'll try to address the situation. Does that make sense, ma'am?
Yes, sir.
What you can't do is just go home, do nothing, and say, well, I'll explain later that I was worried about coronavirus or, I was not feeling well and I didn't do anything. That's not necessarily going to be a defense. You got to reach out and communicate. Do you understand?
Yes, sir.
All right. While you're on probation, I'll order within 60 days of your probation sentence starting that you, in your reporting, within 60 days of your reporting, that you get a mental health evaluation and comply with any recommended treatment. I'll also order that you get a substance abuse evaluation and comply with any recommended treatment. I have no objection to one evaluation if they address all of those issues. Do you understand, ma'am?
Yes, sir.
I'll also order within 60 days of your release from custody that you enroll in a certified batterers intervention program and you complete that program while you are on probation. I'm going to order that you perform 100 hours of alternative community service at a minimum rate of 8 hours a month.
Judge, may I interrupt, sir? Because of her pregnancy and because of the late start with COVID and everything like that, is it possible the community service hours, obviously she can always do more ahead of time, but potentially those start a little bit later than 60 days? Could they start after her pregnancy?
Ma'am, when's your due date?
On November 7th.
Well, under the circumstances, Mr. Consalo, I'm concerned that if we wait until after November 7th, then it could be sometime next year before she's really in a position to do it. Here's what I'm going to do, ma'am. I'm going to order that you perform community service at a minimum rate of 8 hours a month, the way I previously said. Now, I have no objection to probation tolling your community service requirement based on the needs of your pregnancy and or immediately after the birth of your child. Do you understand? But again, that's a situation where you need to communicate with your probation officer. Don't just ignore it and assume, well, I was pregnant. They're not going to give me a hard time about that. If you're not communicating with your probation officer, then things are probably going to be difficult for you. Does that make sense?
Yes.
All right.
Thank you, Judge.
I'm also going to order that you possess no weapons, firearms, or ammunition. I'm going to order that you not possess or consume any illegal drugs or any alcohol. Order restitution reserving as to the amount. Based on the testimony of the victim at our proceeding yesterday, I'll order that you have no hostile or violent contact with the victim while you're on probation. Do you understand, ma'am?
Yes, sir.
It sounds like there are challenges in your relationship based on the incidents I've been made aware of. My advice to you is when those challenges arise, take a walk, cool off, don't engage any further because you have to be concerned about what's going to happen if a law enforcement officer comes out. If they perceive that your contact's hostile, you're going to get arrested, you're going to get violated, and again, you're going to have a difficult situation getting back out of custody. Does that make sense?
Yes, sir.
State, have I omitted or misstated any part of your departure sentence?
I don't believe so, Your Honor. I just wanted to know what Mr. Consalo indicated, whatever prescription medications she has to take for her pregnancy can be excluded from the no illegal drugs or alcohol.
Ma'am, so the order's clear. I have no objection to you taking any prescribed medications in the amounts and dosages as required by your healthcare provider. But you need to provide copies of those prescriptions to your supervising officer so they can confirm if something shows up on a test that it's okay that you're taking that. Does that make sense?
Yes, sir.
All right. I'll also order that you pay any statutory required fines, fees, and costs in this matter. Madam Clerk, can you announce the cost in each of the two cases?
In case number 2019 CF 4223, $415 court costs, a $3 teen court fee, $100 cost of prosecution, $201 battery surcharge, and a $100 contract attorney fee for a total of $819. And in case number 20MM581, $273 court costs with a $50 PD lien, $50 PD assistance fee, and both totals, for a total of $373, and both totals combined are $1,192.
Ma'am, if I give you until January of next year, any reason you can't pay $40 a month towards your cost?
I should be able to.
All right. I'll order as a condition of your probation, starting in January 2021, each and every month you pay $40 a month towards your cost till your costs are paid in full. Anything else, Mr. Gonzalo?
Judge, just to clarify, the court has no objection with her being able to return to the residence where she and the victim share at 2599 Montego Bay Boulevard in Kissimmee, correct?
The defendant may return to the address that she resides at or resided at with the identified victim.
Thank you, sir.
Okay. Anything else, Mr. Carbone?
No, Your Honor, thank you.
Anything else, Ms. Gonzalez? All right, that's the judgment and sentence of the court. Ms. White may be released on these two cases only.
Your Honor, while Mr. Carbone is here, can we have the joint case?
Well, let me do this. Osceola Corrections, I got a backlog of people in my courtroom to address, so I'm going to take care of a few things here, and then I'll circle back to your plea probably in about 20 or 30 minutes, okay? Yes, sir. All right, thank you. Mr. Shields, who's the case with?
I have Tyari Lee, 2019 CF.
Who's the prosecutor?
Oh, it's Ms. Morales, I'm sorry.
All right, so let me do this. I've got a bunch of prosecutors that I suspect are waiting in the lobby of our virtual. So let me see if I can't start getting them in. All right, good morning, Mr. Baird.
Good morning, Your Honor.
I'm trying to get all of our prosecutors in. I've got some lawyers here in the courtroom, so I'm going to do the best I can to be a go-between between the prosecutors appearing virtually and the lawyers in the courtroom. So I think I've got all the prosecutors currently waiting in. All right. So present in the courtroom, Ms. Morales, I have Brock Shields from RCC and Mr. Carbone. They apparently have a case or cases with you.
Yes, so I have the case, Mr. Lee's today. Mr. Carbone has two, I believe, for tomorrow.
Yes, Your Honor, Donald Carbone, 19 CF 3050 and 19 CF 3483.
What's the defendant's last name?
Lee. Yeah, first name is Tyari, and he's present in the courtroom, Your Honor.
Okay.
I'm heading back down, I'll be signing.
Okay.
All right, so what we're asking for, Your Honor, is, I was recently appointed. We're asking for a one-time continuance of the waiver of speedy trial in all our cases. Ms. Morales, can you check the score sheet? I think that there's a few cases that don't score, and can you maybe send me an offer based upon the corrected score sheet?
What's,
There's a bunch of 92, 93 cases that are popping up, and it was like.
So, Mr. Shields, I'm going to try to make this as efficient as possible. That's the kind of stuff you can address between now and the next court. That's fine. Any objection to the continuance in any of the cases, Ms. Morales?
No, Your Honor.
I'll grant the continuance. Mr. Shields, have you filed your motion?
I'll file it today, Your Honor.
All right. And Mr. Carbone, can you file your motions?
Absolutely.
If I set this out for the 9192 pretrials, is that a sufficient time?
Fine.
All right. And do y'all want all the pretrials on the same day?
Yes, we can start on the private.
All right. So on all of Mr. Lee's cases today and tomorrow. We'll reset it to pretrial September 1st, trial period September 14th.
Thank you, Judge.
All right, is that it, Mr. Shields?
I have other cases I'm ready to address. I have Mr. Gavin Prasad. He's in custody.
Who's the prosecutor on Gavin Prasad?
I believe it'd be,
All right, Mr. Baird's appearing virtually.
in Your Honor, we're just waiting. We're gonna ask for a continuance waiver of speedy trial. This is a new case. He has a companion case up in Judge Karsten. I don't think Mr. Baird has an objection to a continuance.
Oh, I apologize, Your Honor. I have Mr. Persaud's case in front of Judge Karsten. I was getting them mixed up. I apologize.
Are you not the prosecutor on Prasad here?
No, it's Ms. Morales.
Okay.
I apologize.
All right. So, Ms. Morales, any objection to Mr. Prasad's continuance?
No objection to the continuance, Your Honor.
Okay. And is this case going to be going to Judge Karsten's division?
I think that one of the prosecutors needs to do a transfer just so we have them in the same courtroom.
Okay.
Judge, if I may, what happened there were there's 4 total co-defendants on the case in Judge Karsten's courtroom. Many of the co-defendants had unrelated cases in other courtrooms, so the administrative order said those did not go with
Correct.
the co-defendant case. That's why they're not together.
Okay. All right. So in other words, this is actually, my case is actually a lower case number, but his cases are not going to transfer here because of the administrative order, because of co-defendants.
That's my understanding. Yes,
Okay.
sir.
All right. So, Mr. Shields, formally, I can't transfer this case.
Understood.
You certainly can negotiate some type of global resolution and either take it in Judge Karsten's courtroom or take it here. Ms. Morales, any objection to the continuance?
No.
Given what I'm hearing, this sounds, Mr. Baird, let me ask you this. How long is it going to take to sort out if there's a global for Mr. Prasad, including his co-defendant case?
Certainly, I can extend an offer with Ms. Morales for a global resolution very quickly. I assume the co-defendant's case is going to take some time for those all to resolve if they're going to trial, because it's a complicated situation.
Okay. Under the circumstances, I'm thinking of continuing this case to the October 6th pretrial, October 19th trial period. Does that seem reasonable?
Perfect.
Ms. Morales?
That's fine with me, Your Honor.
Okay. 10-6, 10-19, it will be. All right, Mr. Shields, anything else?
Yes, last case, Your Honor, she's present, Shaniqua Williams.
Okay, Shaniqua Williams, who's the prosecutor?
Renee Morales on behalf of the state, Your Honor.
All right. And where do we stand in regards to Ms. Williams' case?
Your Honor, the Public Defender's Office withdrew after about a year and a half on this case last week, and because of the confidential informant. And I talked to my client this morning. We have the same conflict.
Okay.
So we're moving the withdrawal early. I'll have a motion filed.
Okay.
Which means to have new counsel appointed.
All right. Has speedy trial, I assume it has to have been waived at some point in the past?
Yes, many times.
All right, so here's what we'll do. In Ms. Williams' case, let's go ahead and find the next attorney on the conflict registry and prepare to appoint them. Mr. Shields, do you need a written motion in order for your file?
I will, what I will do is, my office, just because of their procedure, will file.
Okay.
But if you can orally announce that today, we'll follow up with
All
something
right,
you
so
can.
the court minutes will reflect that I'm allowing Mr. Shields to withdraw, that his office is going to follow up with a written motion in order for my signature. We'll appoint the next attorney up on the conflict registry. I'm going to court continue pretrial of this matter to September 1st with the trial period September 14th. Hopefully that'll be enough time for the new attorney to get involved in the case and be ready to go.
Thank you, Judge. That's all
Is
I
that
have.
it, Mr. Shields?
That's it. Thank you.
All right. Okay. All right. Mr. Mullins, what do you have this morning?
Your Honor, I have 2 matters before the court. Next time I'll bring them both at the same time. This is Ellie Abraham's 2020 CF 1172. Mr. Bain, who was just here, is a state on that case.
Okay.
And I guess he got a new job, so I'm
He
gonna be,
has.
I'm gonna be dealing with somebody else on this. We don't have it resolved yet, but it does look like it's gonna be a plea based on everything we've done so far.
Okay.
So we'll need to continue the case.
How much time?
I'd say if you set it on that September docket, Your Honor, we should have it by then.
Okay. Do we know if Mr. Bain's objecting? I would
No,
assume.
Mr. Bain is okay with it.
I assume he wasn't,
No,
based
he-
on the circumstances.
Yeah.
I'll grant the defense motion to continue. Have you filed the motion?
I can do that. I'll follow it up with.
Just go ahead and follow up with a written motion. I'll grant the continuance, 9/1 pretrial, 9/14 trial period. Tell me about your next.
Okay, the next one I have, Your Honor, Mr. Carmelo Silva, who is present in court. This one looks like it's, there was plea negotiations on it, but that plea offer's been rejected, so we're just gonna have a trial.
Okay. So let's do this. Who's the prosecutor?
State on it is Ms. Gonzalez, Your Honor.
Okay. So I have no reason to believe that I'm going to have jurors in the month of July based on the direction things are going. So the earliest possible time that I'll have jurors would be my trial period that starts August 10th. What I'm inclined to do, Mr. Mullins, is reset you to a private attorney pretrial on July 23rd. And then hopefully by then I'll actually know when I'm going to have juries and we'll go from there.
So they changed it from the 6th? It doesn't look like.
Well, I mean, here's the dilemma. We're moving back to what's called Phase 1, which will be the elevated restricted access to the courthouse. And by Supreme Court order, you have to have at least 30 days of Phase 2 before you can summon jurors to the courthouse.
Gotcha.
So at whatever point we get to Phase 2, then a 30-day clock starts, assuming we stay in Phase 2 for those 30 days, then we get jurors. So I can't imagine with us going back to Phase 1 that we're going to be back to Phase 2 until sometime in mid-July.
Yeah.
It may be longer than that. So
All right, so we'll set it for August, Judge, and we'll be here then. What day was that, Judge?
I'm going to go ahead and use Thursday, July 23rd. It would have been a
Right.
trial day, but
Yeah.
I won't be trying cases, so I might as well be doing something. So let's set Carmelo Silver for private attorney pretrial, July 23rd, and a trial period currently scheduled for August 10th.
All right, thank you, Your Honor.
Judge,
That's all I have.
I will note that it
Hold
was
on. Go ahead. Go ahead.
I will note that it was a withhold probation offer in the case with no cross count.
I couldn't hear that.
Ms. Gonzalez was just noting that the offer is a withhold and probation for Mr. Silva.
And Mr. Silva, who is present, is aware of the fact that it's probation and a withhold of adjudication, and I've explained what that means, and your response is, you're turning that down, right?
Say that again?
You're turning down withhold of, and probation.
Okay.
No, of course not. We got
So,
to
all
try.
right. So he's free to go, you're free to go. Mr. Mullins, we'll see y'all back on July 23rd.
I'm sorry, Your Honor?
We'll see y'all back on July 23rd.
July 23rd.
Okay.
Thank you,
All right.
Your Honor.
All right, Mr. Mosley, you've been sitting here for a good long time, so I'll take you, and then I'm going to start taking some of my virtuals who've been patiently waiting
Good morning, Your Honor.
this morning. Go ahead.
Your Honor, I have a Eunice Vendrell, case number 2019 CF 2756, who's present. And Your Honor, we were going to enter a plea in this case. We had an offer from the state in this case. I don't know if you want to take it today. I did contact your JA about trying to get it on the 26th, but I don't know if you want to do it today or do I follow up on the 26th?
If she doesn't mind waiting this morning, depending on how quickly I'll get through this, I don't mind taking the plea today. So if you want to go over paperwork with her and have her stick around this morning, it might be 11 o'clock, it might be 11:30, but if she stays, I will stay and get her plea done this morning.
Okay.
I don't want her to think it's going to be in the next 10 minutes
Right.
or next 30 minutes. It could be a couple hours from now.
Okay, may I ask?
Sure. Okay, go over the paperwork with her, and then when I get to a lull, I will take her plea.
Thanks, Your Honor.
Okay. All right. Let me take care of a couple of lawyers who've been waiting in the virtual lobby. I'm going to admit Ms. Lopes. Morning, Ms. Lopes. I can see you. But I can't hear you, Ms. Lopes, but maybe you're not saying anything. Ms. Lopes, I think you're on mute because I'm not hearing anything. Ms. Lopes, good morning. Can't hear you. You can't hear me. Can you hear me now? Oh. Ms. Lopes, can you hear me? Ms. Lopes?
Yeah, I can't hear you guys.
I can hear you now. I can hear you. You cannot hear us. So, all right, Ms. Lopes. Let me ask, do either of you have, any of you have the ability to text her or email her real quick?
Can we try to chat with her? There's a chat feature. I don't know if you can see it though.
My guess is that probably her speakers are off for some reason. That'd be my guess as to the issue. All right, let's do this while she's working on her technical issues. Mr. Lejean, what do you have this morning?
I have Mr. Espino, who is in the back. We're still trying to get him into a post-plea mental health court, and frankly, haven't got very far in getting an answer on that due to the pandemic.
Okay.
He has been rejected from a pre-plea one, but I haven't got enough information from them, and I've called several times, and I don't get it. I'm going to go up to the office today to see if there's anything like this there in person, and I don't know.
Who's the prosecutor on Jacob Espino?
Maria Morales for the state, Your Honor.
All right. So, Mr. Lejean,
I'd like to move it one more time to try and get what needs to be accomplished.
Okay.
He's here today in the back.
All right, if I granted the continuance and gave you September 1st pretrial date, do you think that's enough time to navigate the?
The answer to that is yes, but I think I said yes the last time to get to here, and it didn't work, so.
Well, and that's my concern, is that it's probably going to be harder in the next few weeks, possibly all of July, to get any of this stuff done, because
So I
we're
think
moving in
September
the
is our
opposite
best
direction.
hope.
So, have you filed a motion?
No, I haven't.
If you'll just follow up, have your office file the motion to continue, I'll grant it. Pretrial conference will be September 1st. Trial period to be September 14th. If he's been accepted into a program and that's reflected in the clerk's system, then he won't have to be here on the 1st.
Okay.
Your Honor,
Okay.
I'm sorry. Was there any? Does he know why? Like what the delay is? Like, was there anything we can do on our end, or was it? Are we just waiting? I didn't hear.
Well, my understanding is that he was rejected from a pre-plea program.
Correct.
And so now they're exploring post-plea, but the issue at this point is getting a response from the mental health court program.
And frankly, I haven't got an application in because I keep talking and I haven't really got what I need from them. And to tell you the truth, I haven't done a post-plea one before, so I'm sort of walking in the dark.
Okay. So Mr. Lejean is trying to navigate the post-plea system, so I'm going to continue it to September 1st. We'll see what happens.
Okay, I have there's like a link for a form stack that the circuit has. I'm gonna email that to him. It's pretty easy to do from his own office.
All right, the state's going to email a link to your office that should take you directly to the forms, and potentially that will help.
Yes. Jello, thank you very much.
All right, he says thank you very much.
Thank you. The only thing I would note is I came in person today because I've had 2 hearings already where they couldn't hear me.
Right.
So I sympathize for that attorney because I don't know what I did, and I'm sure she doesn't know what she did either.
Right. Well, I was going to say, did you ever have to run court in such a demanding, ongoing?
No, I mean, we had it,
Right.
you know, hurricanes was the worst thing we had, and that was probably even, I think the worst one was Charlie, and it was only 2 weeks.
Yep.
So
All
this
right.
is much worse.
Have a wonderful day.
You too.
All right, Ms. Lopes, can you hear me now?
I can, Judge. Can you hear me?
Yes, we can. We have succeeded. All right, what do you have this morning?
We have, Tennessee steps, we have case 19 CF 1950, ACCF 469, ACCF 4361.
Okay. And where do we stand with those cases?
We are still in trial posture, Your Honor.
Okay. And Ms. Rosado, I assume that you have, do you have all the cases?
I do, Judge.
Okay. Are you still in trial posture?
Yes, we're just waiting on the Williams rule stuff from you. Remember, I provided you with everything. And then we're just...
Right, so I'm trying to refresh my recollection on how far we got in that process.
We didn't get very far. You were going to review the items and then determine whether or not we can go forward with our live testimony, if that
Okay.
was enough. And then we were just going to make arguments. Set it for-
And when you say you supplied the items, what is it specifically that you supplied?
I supplied the police reports, the audio statements, as well as the deposition statements.
And what form were the audio statements in?
CD. Everything was in the CD.
So reach out to my JA because I'm not aware. Typically when that stuff comes in, it's placed on my desk and the CD is usually on the top. And that's kind of my trigger that this is something I need to listen to. So,
Judge, we provided that to you in court. We had an actual hearing. It was in court.
all right, I will double check and see, where it is at this point in time. Was it filed into evidence or just provided to me as a courtesy copy?
It was just provided to you as a courtesy copy, I believe. I will follow up with Ms. Hall. If anything, I could just resend the items.
Right, yeah, let me check today and make sure that it hasn't snuck off to some, hidden place within my chambers. But you may want to check with my JA today, make sure that in fact I have it. And then I'll review it. And I guess the only silver lining is we're going to have plenty of hearing time, depending. I think the only challenge is going to be if we're going to be taking live testimony, then I think at this point, realistically, our only way to do that is going to be through some type of virtual process where everyone's appearing via Teams. And so the lawyers might need to work out a few kinks to make sure that we don't have a problem with that. So as far as a trial date, I think the earliest possible date that I'll have jurors will be August 10th. I'm not promising them to have jurors on August 10th, but I think that's the earliest possible date that I'd have jurors. So what I can do is reset this case, all 3 cases, to July 23rd. I'm going to use that as a private attorney pretrial. And then hopefully by July 23rd, I'll have an idea of when we have jurors, and we may have already had a hearing at that point in time. Otherwise, we can talk about when we'll have the hearing, if we're having a hearing on Williams Rule.
No problem, Judge.
Ms. Lopes, does that work for you?
Yes, that's fine. Just in my calendar. Yeah, it's good.
Okay, and it'll be almost certainly a virtual pretrial on the 23rd. So, all right, so each of Mr. Essep's case, I'm just going to reset pretrial to Thursday, July 23rd at 9 a.m. And Ms. Rosado, just follow up with my J to make sure that I have all that material to review, okay?
No problem, Judge. Thank you.
All right, Ms. Lopes, anything else?
Yeah, sorry about the mix-up in my hearing and the audio.
It's all right. Once we all get really good at this, things will become fine and we will quit using the technology. And then who knows? All right. Thank you. Have a good day.
Okay, bye-bye.
I'm going to go ahead and admit Mr. Parker. Mr. Freenis, for your benefit, I'm just going to kind of clear out the backlog and then I'll circle back and take your plea. Do you have a pressing time? Okay. All right. Morning, Mr. Parker.
Morning, Judge.
What do you have today?
I have 2 cases, or I guess 2 clients, 3 cases. So the first one is Jose Roman Ruiz. He has 2 cases with Mr. Bain.
Okay.
There's a co-defendant as well who's represented by Mr. Kelly. These are cases, Judge, they've kind of been geared up for trial. We have 1 deposition, I believe, left of the state's main witness in this case. I don't know if Your Honor has already addressed the co-defendant's case or...
I don't think so. And Mr. Bain was supposed to be logging in virtually, but I don't see him in the meeting and I don't see him in the lobby waiting to be admitted. Does someone know what Mr. Bain's status is?
Judge, I can just tell you that there's 1 witness that we need to depose, and then these cases are going to be ready for trial.
Okay. Do you have that deposition currently scheduled?
We don't. I know that we had it scheduled, and then we were potentially working out some kind of agreement, but I think we're kind of to the point where that's not going to happen, at least on my end, so it shouldn't be difficult. We've been in communication with the agent who's kind of willing to cooperate with us whenever we can get a time.
Okay.
I don't know who's going to be taking over the case, but I don't anticipate it taking too long to get the deposition done. Just, with everything that's going on, it has been scheduled.
Okay. Looks like Mr. Bain is joining us. All right, Mr. Bain, Mr. Parker was just telling me about Roman Ruiz. He says there's 1 deposition to be completed, and then the case is ready to be tried. So here's my thought. The earliest I'm going to have jurors realistically would be August 10th. So what I'm contemplating is just resetting the pretrial of this case to July 23rd. Hopefully by then we'll know when we have jurors and y'all can tell me if the depo's been completed or at least if it's scheduled. And then we will figure out when to give Mr. Roman Ruiz and his co-defendant a trial.
All right, and we're coordinating with Mr. Kelly because I haven't seen the depot coordination about that.
No, sorry, Andrew, for Ms. Bain. No, I told him we hadn't coordinated it yet, but I will coordinate it with Mr. Kelly.
Okay.
And then things that are also not, we're going to trial, then you're not taking any other offers and things like that.
I know. My client has declined all the offers from the state at this point.
Okay. So I'll reset Roman Ruiz to pretrial on July 23rd at 9 a.m. Trial period August 10th, and we'll see where everyone stands then.
And Ms. Bain, should I just go ahead and coordinate it with your assistant for whoever's taken over?
Yeah, just go ahead and contact Debbie and we'll get it coordinated. But obviously, that may be subject to change. I don't know who's, because I'm also covering another docket for another attorney. So the folks coming in is going to be covering 2 dockets. So I've got to kind of fit it in where everything's going to fit to that moment.
I got you. Okay, thanks. Just the only other case we have, it's Salvador Gonzalez. I believe that is with Miss Rosado. And it's case number 2020 CF 1050. And we were requesting a continuance in this case with a waiver of speedy trial. We filed a motion to continue. It's the first time that we've received some of the discovery from the state, so we just need more time to review that.
Tell me who the defendant is again.
It's Salvador Gonzalez.
All right, and Ms. Rosado, any objection to a continuance?
No objection, Judge.
How far out do I need to set this case?
I would say probably at least 2 or 3 dockets. We're not going to jurors. Sounds like until August. I think 2 or 3 dockets at least.
Is he under Salvador or under Gonzalez on the docket?
He may be under.
I found it.
Are you okay?
Yeah, it's on the docket. It says Guardalio Gonzalez. So,
Oh, God.
have you filed a motion to continue?
We did, Judge.
All right, and no objection, correct?
Correct, Judge.
All right, I will grant the continuance. I'll find a waiver of speedy trial. I'm going to set this one out to October 6th pretrial and October 19th trial period, and we will go from there.
Thank you, Judge.
All right, is that it, Mr. Parker?
That's it, Judge.
All right, have a good day.
Thank you, Mr. Zotto.
All right, State, I just realized that Judge Karsten's waiting for the jail feed. So, Mr. Farinas, if I can get an interpreter, can we take this? Let's see if I've got an interpreter.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn.
All right, good morning, Ms. Romero. This is Judge Wooten down in Division 201. I'm going to have a defendant at the Osceola County Jail who needs your services. Osceola Corrections, can you have our defendant, Mr. Bolarin Almadina, step up? Ms. Romero, this is case number 2010 CF 2872. The defendant is standing at the microphone at the Osceola County Jail.
Thank you, Your Honor. Thank you, Your Honor. Buenos días, señor Medina. ¿Puede escuchar la intérprete?
Sí. Right.
He can hear the interpreter, Your Honor.
Let's go ahead and swear him in.
You raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth to help you God.
Levante su mano derecha. Usted solemnemente jura que el testimonio que va a presentar en esta causa va a ser la verdad, toda la verdad y nada más que la verdad ante Dios. Sí. Yes.
Good morning, sir. Tell me your name and your date of birth. Good morning, sir. Tell me your name and your date of birth.
Buenos días. ¿Su nombre completo y fecha de nacimiento?
Juan Bolarín Medina, 930 de 61.
Juan Bolarín Medina, 93061.
Sir, you previously were placed on probation for trafficking in oxycodone, a first-degree felony punishable by up to 30 years in prison.
I'm sorry, Your Honor. Could you repeat the punishment?
It's a first-degree felony punishable up to 30 years in prison.
Señor, usted fue puesto en probatoria por un caso de tráfico de oxicodón que llevaba una posible pena de hasta 30 años en prisión.
It's now been alleged that you have violated your probation. Do you understand the original charge and the allegation of violation?
Ahora se alega que usted ha incumplido su probatoria. ¿Usted entiende la acusación original y lo que se alega que se ha incumplido en el caso de incumplimiento de probatoria?
Sí.
Yes.
Standing in the courtroom is your attorney, Mr. Farinas. Mr. Farinas, can you tell us the proposed resolution when the interpreter is done?
Aquí en la sala está su abogado, el señor Farinas. El juez le está pidiendo al señor Farinas que nos diga cuál es la propuesta de resolución para el caso.
Yes, good morning, Your Honor. Brian Farinas on behalf of Mr. Bolorin. The agreed to disposition is going to be an admission to Condition 7. It's going to be revoke and terminate probation, sentenced to 30.15 months DOC. with credit for 701 days. Credit time served.
Este es el señor Farias. En caso del señor Bolorín, el acuerdo es que él va a estar haciendo una admisión en el caso de incumplimiento de probatoria a la condición número 7. El acuerdo es que se les revoca y termina la probatoria y se le sentencia a 30.15 en puntos en el Departamento de Correcciones con crédito por 701 días, tiempo ya cumplido.
Question for the state attorney. Number one, is this your agreement? And number two, is this a departure sentence?
Yes, Judge, yes.
Pregunta para el fiscal que el juez tenía si este es el acuerdo de declaración y si esta es una sentencia más baja. Sí.
All right. Mr. Bolarin, is this how you want to resolve your case?
Señor Bolarín, ¿esta es la forma en que usted quiere resolver su caso?
Sí.
Yes.
As you stand here today, are you under the influence of any drugs, alcohol, or medication?
Según usted está aquí en el día de hoy, ¿está usted bajo el efecto de drogas, alcohol o medicamentos?
No.
No.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
¿Alguna vez usted ha sufrido de algún trastorno mental, alguna enfermedad mental o está sufriendo de alguna de estas condiciones en este momento?
No.
No.
Do you read and understand the Spanish language?
¿Usted lee y entiende el idioma de español?
Sí.
Yes.
Your attorney has given me a document called a plea form or an admission form. It's a 2-page document printed in Spanish with your name and case number on it.
Su abogado me ha dado un documento aquí que es de admisión, un formulario de admisión. Tiene 2 páginas, está escrito en español y tiene su firma.
Did you go over this form with your attorney, Mr. Farinas?
¿Usted repasó este formulario con su abogado, el señor Farinas?
Sí.
Yes.
Did he answer any questions you had about your rights as explained in this form?
Él contestó cualquier pregunta que usted puede haber tenido en cuanto a sus derechos que están escritos en este formulario.
Sí.
Yes.
Did you sign the form?
¿Usted firmó este formulario?
Sí.
Yes.
Do you understand that you're admitting you violated your probation today, which means there will not be a hearing and I will sentence you this morning?
Usted está admitiendo que usted incumplió la probatoria, por lo tanto no se va a llevar a cabo una audiencia y usted entiende que el juez le estará sentenciando aquí en esta mañana.
Sí.
Yes.
Has anyone forced, threatened, or coerced you to make this admission?
¿Alguien le ha forzado, obligado, amenazado a usted en cambio de que usted haga esta admisión?
No.
No.
Other than what's been explained in this courtroom, has anyone made any other promises to you about the sentence you would receive?
Aparte de lo que se ha dicho aquí en esta sala en el día de hoy, lo que se le ha explicado, ¿alguien le ha hecho a usted alguna promesa en cambio de su declaración?
No.
No.
Are you satisfied with the work Mr. Farinas has done?
¿Está usted satisfecho con el trabajo que el señor Farinas ha llevado a cabo?
Sí.
Yes.
Do you understand, sir, if you are not a citizen of the United States, entry of this admission would result in your deportation?
Señor, ¿usted entiende que si usted no es ciudadano de los Estados Unidos, el asentar esta declaración pues va a resultar en que usted sea deportado?
Sí, entiendo.
Yes, I understand.
Mr. Farinas, are you conceding that the affidavit of violation sets out a factual basis to find your client willfully violated his probation?
Yes, Your Honor.
El juez le ha preguntado al señor Farinas si está de acuerdo que la affidavit de incumplimiento de probatoria explica la admisión o respalda la admisión que el señor está haciendo en el caso de incumplimiento de probatoria. Sí, su señoría.
Sir, I'm going to accept your admission. I find you're alert and intelligent. Your admission is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied.
Señor, yo voy a aceptar su declaración. Yo hallo que en el caso de incumplimiento de probatoria, hallo que usted está alerta, es inteligente y que su admisión es libre y voluntaria y está satisfecho con la representación que ha recibido.
Sí, estoy de acuerdo.
Yes, I agree.
Is there any legal reason why sentence should not be imposed, Mr. Farinas?
No, Your Honor.
¿Alguna razón legal por la cual no se debe de imponer la sentencia, señor Farinas? No, su señoría.
All right, sir, the court having accepted your plea, I will find you in violation of probation. I'll revoke and terminate your probation. I'll adjudicate you guilty, and I'll sentence you to 30.15 months in the Department of Corrections.
Bien, señor, yo acepto su declaración. Yo hallo que su declaración es libre y voluntaria. El caso de incumplimiento de probatoria se revoca y termina la probatoria que tenía. Se le condena culpable y se le sentencia a 30.15 meses en el Departamento de Correcciones.
I'll give you credit for 701, that's 701 days in the Osceola County Jail.
Yo le voy a dar crédito por 701 días, tiempo que ha cumplido en la cárcel del condado de Osceola.
I'll also order that you pay any fines, fees, or cost associated with this violation and whatever unpaid balance remains on your case.
Yo le ordeno a pagar multas, costas judiciales, costas procesales del caso de incumplimiento de probatoria y cualquier otro dinero que esté aún pendiente debiendo. Aún está ordenado a pagarlo.
Madam Clerk, can you announce the new cost and any unpaid balance?
There's an additional $100 cost of prosecution. He has an outstanding balance of $54,009.72 for a total of $54,109.72.
Madam Clerk, can you repeat the total amount due, please?
$54,109.72.
Se le añaden otros $100 costas procesales y el total debiendo con toda, en lo previo y ahora son $54,109.72.
All right, sir, I'm going to order within 90 days of your release from custody that you contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $75 a month towards your costs until your costs are paid in full.
Bien, señor, yo le estoy ordenando que en los próximos 90 días después de haber salido, usted se comunique con la secretaria del actuario de la corte para que le pongan en un plan de pago y se le va a ordenar a pagar $75 al mes de ahí en adelante hasta que haya pagado todo el saldo que tiene pendiente. Okay.
Anything else, Mr. Farinas?
No, Your Honor.
Anything
¿Alguna
else,
otra
Mr.
cosa,
Bain?
señor Farinas?
No, Your Honor.
Anything
Señor
else,
Bain?
Madam Clerk?
No, sir.
¿Algo más del actuario? No, su señoría.
This is a departure sentence negotiated by the state and the defense. It is the judgment and sentence of the court. The defendant is remanded to the Department of Corrections at this time.
Esta sentencia es una sentencia más baja acordada con la Fiscalía y la Defensa. El acusado queda detenido para cumplir el resto de su sentencia. Gracias, eso es todo.
All right. Ms. Romero, that is the end of your services as far as I know.
Thank you, Your Honor.
Have a wonderful
Have a
day.
great day. Thank you, you too.
You may, Mr. Farinas. All right, Osceola Corrections. I'm done with the video link. My understanding is Judge Karsten is waiting for you, so you're welcome to start bringing his people in. And I'll ask my court deputies, can we disconnect the link on our end?
Thank you, Judge.
Okay. Bert, can we, I don't want to be hearing or seeing what they're doing.
Did you call Jerry Fulton this morning for arraignment? I believe he was.
I've not called anybody for
He was
arraignment.
in custody.
Okay.
I'll just file our waiver right now. I thought the state attorneys were going to be here.
Okay.
I forgot it was pretrial virtual.
So on Jerry Fulton on the arraignment docket, we'll do a waiver of arraignment. I'll just go ahead and set him for the 9/2/9/14 dates.
Yes, and I believe it'll be resolved before then.
Okay, all right. Is that it, Mr. Carbone?
Yes, Your Honor.
All right, I'm going to go back to virtual pretrial. I'm going to admit Caitlin Reese.
Assume you're the state.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right, good afternoon. As was explained to you on the video, you're here for initial appearance today. I've reviewed all but the last couple of cases, and based on the court's review of the affidavits, I do find that there's a factual basis upon which or there's a probable cause that you committed the offenses for which you've been arrested, unless I indicate otherwise when your case is called. You all have the right to be represented by a lawyer, and unless you affirmatively tell me that you are represented by a private attorney, I'll be appointing the office of the public defender to represent you this afternoon. We'll start with our interpreter cases.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has already been sworn in today.
All right, good afternoon, Mr. Morales. We're here for initial appearances, so the folks will not have the headsets on. We're going to start with case 20 CF 1766, State versus Nakina Calderon.
Your Honor, she's on her way here.
Okay.
And so is Ms. Clark. And so is M.A. Dockett.
All right, well, we'll pass
We can
Ms.
start with, if you can, Espinance.
Yeah, we'll pass Ms. Calderon for the moment and call the interpreter back. We will pass Ms. Calderon for the moment, and we will call the interpreter back when we get to her.
Okay, thank you.
All right, Yahaira Espinal Gonzalez.
Your Honor, I'm sorry, was that the only interpreter case then?
No, it wasn't. We have a couple of them. We're waiting on Ms. Espinal Gonzalez. Was she not brought over yet either?
No, sir, she's on her way.
All right, we'll pass her as well. And the next interpreter case we have is Alcide Maldonado Rosado.
Are you here? Come on.
All right, good afternoon. State your name.
Buenas tardes. Diga su nombre.
Alcides Maldonado Rosado.
Alcides Maldonado Rosado.
Mr. Maldonado Rosado, you were arrested for petty theft and battery.
Señor Maldonado Rosado, usted fue arrestado por hurto menor y agresión.
Yes.
Your bond is $1,000 on the petty theft with prior theft conviction and $500 on the battery charge.
La fianza por el caso de hurto menor es de $1,000, teniendo condenas anteriores, y la fianza por el cargo de agresión es de $500.
You are currently out on bond in Osceola County cases 20 CF 1300 and 20 CF 1301.
Actualmente usted se encontraba libre por los casos donde había pagado fianza ya, casos de Osceola 20 CF 1300 y 20 CF 1301.
And also 20 MM 1300.
Y también el número de causa 20 MM 1300.
Your bond in each of those cases is revoked and discharged at this time. You'll be held without bond until further order of the court in each of those cases.
La fianza en cada uno de esos casos queda revocada y será detenido, se quedará detenido sin fianza hasta nuevo aviso de un tribunal.
The Public Defender's Office is appointed to represent you in this case. Your next court date will be, no, this case is a misdemeanor. Oh, it's two or more prior convictions, yes. Your next court date will be on demand in circuit court, sir.
La próxima vista que tendrá será asignada cuando se determine y se le han nombrado los defensores públicos para que lo representen.
Thank you.
Your Honor, can the interpreter get the case number for the original case? I mean,
The case number is 20 CF 1754.
thank you.
All right, thank you, sir. You may have a seat. All right, that's all the interpreter cases we have for now. We'll call you back when we get the
Yes,
other
Your Honor.
inmates brought.
Thank you.
All right, Franklin Flanders. State your name, please.
Franklin Flanders.
Ms. Flanders, you were arrested on a warrant for violation of probation in case 18 CF 3197 on a charge of possession of cocaine. Your bond is set at $0. Based on the nature of the allegation, I will set bond in the amount of $1,000. The Public Defender's Office is appointed to represent you. Your next court date is?
Next court date, August 18th, in courtroom 5F at 8:30 a.m.
Thank you.
Judge, I also wanted you to be aware this, Flanders is also out on bond in 1972.
That's all right. I'm not going to take any action. Thank you, Mr. Flanders. Brandon Stringer.
I'm sorry, Your Honor, can you repeat?
He what?
Can you repeat the name?
Brandon Stringer.
Your Honor, he has to be done separate from these individuals due to the quarantine.
All right. Make him our third group, okay? Donald Vaughn. State your name, please.
Donald Vaughn.
Ms. Vaughn, you arrested on a warrant charging you with burglary of a dwelling, grand theft, and criminal mischief. You have a bond of $5,000 on the burglary charge, $150 on each of the other two counts. The Public Defender's Office is appointed to represent you in this case. You are presently out on bond and pretrial release in case 20 CF 46. Based on this arrest, the court finds a violation of the conditions of the bond and pretrial release, and I will revoke the bond and pretrial release in that case. You'll be held without bond in that case pending further order of the court. Your next court date will be on demand in circuit court. Thank you. Are you ready for the case? Yes. Who do you have?
David Smith, 20 MM 1481. I just got this today, so.
All right, David Smith?
My name's David Smith.
No, not, excuse me one second. Yes, I did. All right, Mr. Smith, you arrested on a charge of battery. Your bond was set at 0. Mr. Mullins is here on your behalf. There's also a witness. So, Ms. Mullins, if you'll step aside for just a moment.
Sure.
And ma'am, if you'll please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And what is your name, please?
Martha J. Smith.
All right, Ms. Smith, you are listed as a victim in this case. The court is considering conditions of release. I'm interested in any input you want to provide to the court with respect to what conditions you would be looking for.
Just for my husband to have some counseling on anger management.
Okay. Well, that may be able to happen down the road a little bit. That's not something I can order right at this moment.
Okay.
Are you wanting to have contact with him at this time or not at this time?
I can have contact with him.
So you want him to be allowed to return to the residence?
Yes, sir.
Are you afraid of Mr. Smith?
No, I'm not.
If something like this were to happen in the future, would you hesitate to call the police and let them know?
Not at all.
Ms. Bain, any questions?
You say we still be asking for no contact, Judge. I understand that.
Right, I'm just asking.
I
if you have any
I
questions.
have no questions, Judge, no.
Mr. Mullins, any questions?
You operate a restaurant?
Yes.
With,
I do.
do you find it necessary to work together?
We have to, yes.
All right, any prior history?
Judge, little history going back to 1986. DUI was found guilty in 1991. Had an aggravated battery with a deadly weapon. Those charges were from history out of the state of Ohio, with another DUI in California with
Then, Mr. Bain, argument.
Judge, to say we asking for no contact, let the assigned judge handle that, whether contact is appropriate at this time, but not based on these facts.
All right, Mr. Smith, your offense doesn't qualify for straight pretrial release. So I'm going to set bond, in this case, the amount of $500. It will be conditioned upon supervision by pretrial release with mental health conditions. It will further be conditioned upon you not having any hostile contact with Martha Smith. That's no pushing, no shoving, no biting, no scratching, no fighting. You will not possess any weapons or firearms of any kind. You will not possess or consume any alcoholic beverages or any controlled substances without a valid prescription. Your next court date will be,
It's still in jail, July 2nd. It filed July 27th in courtroom 4A at 10 a.m.
all right, so Ms. Smith, Mr. Mullins can probably tell you how to arrange for football if you wish to do so. He is allowed to have contact, just no hostile contact. All right, thank you.
Thank you, Your Honor. That's all.
Thank you, Mr. Smith. That's all. Mr. Luca, did you have a case you want? Okay, we'll go through these first then. All right, Tarsha Clark Stevens. Or Tasha Clark Stevens. State your name, please.
Clifford Esperance.
I'm sorry? What is your name?
Clifford Esperance.
Well, that's not who I called, but okay, well, since we have you here, we'll address it.
Who did you call?
All right, it's all right, I'll address the man who's here. All right, Mr. Esperance, you arrested on charge of battery. Your bond was set at 0. We have a witness here, so I want to take some testimony from the witness, and then we'll proceed. The Public Defender's Office is appointed to represent you. I said the victim. All right, good afternoon, ma'am. What is your name? I'm sorry?
Layla
You have a last name?
Esperance.
Okay. All right, Mr. Esperance, just for your information, Layla Esperance is here. All right, any prior history?
The defendant has history going back to 2004, domestic aggravated battery on a pregnant woman. Those charges were given pretrial diversion. 2009, domestic battery, aggravated battery with a deadly weapon. Those charges were dropped. We were not able to contact the victim in this case.
All right. Mr. Esperance, I'm going to set bond in your case in the amount of $500. It will be conditioned upon you not having contact directly or indirectly with Jordan Elijah Esperance until further order of the court. So no contact whatsoever. If he attempts to contact you, you'll have to, he has to be informed that he cannot do that until the court modifies the order. You are not to possess or consume any alcoholic beverages at all, or any controlled substance without a valid prescription. You'll be subject to testing to make sure that you're not drinking alcohol or using controlled substances. You will not possess any weapons or firearms. The next court date will be,
It's still in jail July 2nd and filed July 20th in courtroom 5B at 10:30 a.m.
thank you. Thank you, ma'am.
Your Honor, on Esperance, what was the bond amount?
500.
Thank you.
Cartasha Clark Stevens. Good afternoon. Okay, Ms. Clark Stevens, you arrested for aggravated battery, armed burglary of a dwelling, and false imprisonment. Your bond is $3,500 on the aggravated battery, $3,000 for false imprisonment, and 0 at this time on the armed burglary. Any prior history?
No prior history, Judge.
State, did you wish to be heard as with respect to bond on the armed burglary charge?
Scissors, that case. Proof evident presumption, great judge, but I think she's entitled to bond at this point.
She's not entitled to bond as a matter of right.
As a matter of right.
Sorry?
I kind of would like to have more information from the victim judge before I'm agreeing to a bond amount,
All right.
as that bond be stated at this moment. But obviously, we can have an Arthur hearing later on.
Ms. Clark Stevens, the bond is going to remain at 0 on the armed burglary charge at this time. The Public Defender's Office is appointed to represent you. Your attorney can schedule a bond hearing before the court that will be hearing your case, but I'm not going to set bond this afternoon.
Your Honor,
Yes.
I apologize for the interruption. I was just waiting. Mary Jane Cooper on behalf of the Public Defender's Office. With regard to the proof evident presumption great argument.
The court's not finding proof evident presumption great. There's a split amongst the District Court of Appeals, Courts of Appeal. The court follows the rationale of the Third District Court of Appeal, which holds that that is not a finding that has to be made for bond to remain at 0 at an initial appearance. So,
Yes, Your Honor, I understand. If I may, I just wanted to make sure that for the record, for 0 bond for this particular offense, I believe case law does indicate that the alleged victim should be testifying that it cannot go on the sole sworn affidavit of law enforcement for zero bond.
The bond's going to remain at zero at this time. Your attorney will be in touch, and they can schedule a bond hearing. Your next court date will be on demand in circuit court. Thank you. Edward Dacius. Edward Dacius.
Your Honor, he is on the way. He's one of our special candidates.
Put him in group 3. All right, Demi Garcia. Good afternoon, ma'am. Please tell us your name.
Demi Garcia.
Ms. Garcia, you're arrested on a charge of battery. Your bond was set at 0. Any prior history on Ms.
No
Garcia?
priors, Judge, and the victim is requesting time.
All right, state you wish to be heard.
Is it a contact, Judge? He's not here to testify to that. I think the statute says that he has to be here to give some kind of sworn testimony as to whether he wants contact or not.
Yeah. Ms. Garcia, I'm going to set bond in your case amount of $100. It will be conditioned upon supervision by pretrial release. However, we haven't heard from the alleged victim here in court. So at this time, until further order of the court, it will be conditioned upon you not having contact with Luis Cartagena Reyes. You will not return to the residence at 8919 Legacy Court, Apartment 304. You may do so on one occasion accompanied by a law enforcement officer to pick up clothing or personal possessions you need from that residence. Now, those conditions are subject to change once more information can be obtained. But until or unless the court changes them, you cannot have contact even if he wishes to have contact. If you were to have contact, that would be a violation of the conditions of release. You could be then held in jail without bond until the case is resolved. So I would suggest that you communicate immediately with the Office of the Public Defender. They can schedule a hearing quickly before the judge will be hearing your case. But at least on a temporary basis, you will have to find another place to stay. Again, the Public Defender's Office is appointed. Your next court date will be
Next court date, if still in jail, July 2nd. If out, July 20th, in court room 5B at 10:30 a.m.
Fernando Garcia Sanchez.
Your Honor, Mary Jane Cooper, on behalf of the Public Defender's Office, I do have a probable cause argument for this, just to confirm.
State your name, please.
Fernando Garcia Sanchez.
All right, Mr. Garcia Sanchez, you were arrested on charges of robbery by sudden snatching, grand theft, and aggravated battery. Your bond is presently $1,000 for the robbery, $500 for the grand theft, $3,500 for the aggravated battery, and yes, you may proceed.
Yes, Your Honor. With regard to aggravated battery, bodily harm, disability, under Florida Statute 784.045, subsection 1A1, I would like to argue that there was no probable cause based on the fact that a deadly weapon was not involved. There is no evidence of great bodily harm or permanent disability or disfigurement. I would argue that this should be amended to a battery touch or strike under 784.03 1A1.
State you wish to be heard.
Judge, as far as great bodily harm or permanent disfigurement, paragraph during my investigation, I observed the victim had multiple lacerations to his forehead. His face was covered in blood. His white shirt was stained with blood. Also, I believe they located a pool of blood in the middle of the parking lot. Those are all jury questions as to how much damage he did or whether he broke anything, but nothing that caused you to bleed and caused medical attention at this point. I believe it's probable cause as to whether a great bodily injury or permanent disfigurement was
It's a close call. There's no indication of any weapon. The question is whether the lacerations, alleged lacerations are sufficient to constitute great bodily harm. On a probable cause determination, I will find that is sufficient.
Your Honor, if I may, I understand that there was blood, but I do not feel that that's sufficient to provide for probable cause based on the fact that an amount of blood cannot prove there's permanent disability or disfigurement or great bodily harm. And without the injury, it can't be
Question is whether
proven.
lacerations are sufficient to constitute great bodily harm, which
Exactly.
is a jury question. It's more than a mere bruise or contusion. Again, I note your objection, but I do find probable cause at this time. So, Mr. Garcia Sanchez, your bond is set at, as indicated, your next court date is on demand in circuit court. The public defender's office is appointed to represent you.
Judge, can I just get a no contact order?
Well, I'll order no contact with the named victim, but
Yeah, I just want to make sure, because
I doubt that they know where each other live since this was a Lyft driver.
somehow that seems not to happen a lot of times in my aggravated battery cases.
Thank you, sir. William Haney? Good afternoon. State your name, please.
William Haney.
Mr. Haney, you arrested on a charge of battery. Your bond was set at 0. I am aware that you're out on bond in another case on a charge of battery with 2 prior batteries. Any prior history other than that?
Has extensive history going back to 1974, charges of burglary with assault, several failure to appears, charge of child abuse, which he was found guilty. Most recently, failure to appear on the case that he's out on bond. We were not able to contact the victim.
All right, Mr. Haney, I'm going to set bond in the new case in the amount of $1,000. It will be conditioned upon you not having contact directly or indirectly with Ms. Brower. That's Jody Brower. You will not possess any weapons or firearms. Based on this alleged offense occurring while you're out on bond for a charge of battery with 2 prior batteries, I'm going to revoke the bond or other conditions of release in case 19 CF 3925 in order to be held without bond pending further order of the court in that case. Your next court date at this time will be
If still in jail, July 2nd. If out, July 20th in courtroom 4E at 9:30 a.m.
Thank you, sir. Thank you. John Harrison.
Your Honor, that's another one coming from our medical unit. He should be here shortly.
All right. Put him in one of our many stacks. All right, Sam Shinkman.
I'm sorry, Your Honor, can you repeat?
Sam Shinkman.
Yes, Your Honor, he's on his way up.
All right, Michael Starling. Afternoon, state your name, please.
I'm Michael Starr.
Mr. Starling, you were arrested on a charge of battery. Your bond was set at 0. Do we have any information on
2013, an arrest for possession of cannabis and drug paraphernalia, and 2 failure to appears on that case. He was adjudicated withheld, and we couldn't contact the victim to that.
All right, Mr. Starling, I'm going to set bond in your case the amount of $500. It will be conditioned upon supervision by pretrial release. If you do post bond, you will not return to the area of suburban estates in St. Cloud. You may do so on one occasion to retrieve any clothing or personal possessions you may have at that address or that area. You will not have contact directly or indirectly with Brandy Crystal Collins. You will not possess any weapons or firearms of any kind. Public Defender's Office is appointed. Your next court date will be
Is still in jail July 2nd and filed July 27th in court 4A at 10 a.m.
Will I be able to get that information from somebody?
Sorry, sir?
Will I be able to get that information from somebody?
Get that information.
Yeah, the next court date?
Right. When you meet with pretrial release, they'll have all that information for you, and you'll get paperwork with that. All right, thank you. Jonathan Kowalski?
Mary Jane Cooper, on behalf of Mr. Kowalski from the Public Defender's Office, we'd like to waive a reading of the charges.
Mr. Kowalski, you arrested on a new case as well as violation of probation on your old case. Are you aware of what the charges are, sir?
Yes.
Okay. I'm going to set bond on the new charge in the amount of $2,500. It's going to remain zero in the violation of probation at this time. The Public Defender's Office does represent you in this case. Your next court date will be on demand in circuit court. Thank you, sir.
Next court date for 2013 CF 2476, June 29th in courtroom 5F at 8:15 a.m.
Shannon Morgan. All right, state your name, please.
Shannon Morgan.
Ms. Morgan, you were arrested on a charge of battery. Your bond was set at zero. Do you have any prior history?
No priors, Judge, and we were not able to contact the victim.
Ms. Morgan, I'm going to set bond in your case in the amount of $100. However, it will be conditioned upon supervision by pretrial release, and there are going to be some conditions on your release that you have to comply with until further order of the court. You will not return to the area of 4194 Quailwood Drive in St. Cloud, except you may do so one time accompanied by a law enforcement officer to pick up clothing or personal possessions you need from that address. You will not have contact directly or indirectly with Hunter
Wright, Your Honor.
Sorry?
The last name is Wright.
Hunter Wright. Thank you, ma'am.
Welcome.
Okay, so no contact with Mr. Wright. You will not possess any weapons or firearms. And Ms. Morgan, those conditions are subject to modification, so talk to your lawyer about that if you want to return, if you want to have contact. That may very well be possible. It's just not going to be possible until the court gets more information. All right, your next court date will be
Is still in jail July 2nd and filed July 20th in courtroom 4E at 10 a.m.
Nasser Mohammed.
Your Honor, I have a probable cause argument for this case as well.
State your name, please.
Nasir Muhammad.
Mr. Mohammed, you arrested on several charges, trespass on a post-construction site, 2 counts of resisting an officer without violence, 1 count of loitering or prowling. Your bond in that case presently totals $3,500. Also burglary of a dwelling and petty theft. Your bond in that case totals $10,500. And yes.
Yes, Your Honor. Mary Jane Cooper on behalf of the Public Defender's Office for Mr. Mohammed. I have a couple probable cause arguments. First and foremost, with one of the charges of resisting without violence. It is specifically stated in the charging affidavit that the resisting was due to ignored commands to stop, but fleeing. There is case law, which is Mosley v. State, 739 Southern 2nd, 672, that indicates that flight alone does not provide a well-founded suspicion, nor does it provide probable cause. So my argument is there is no probable cause for this one count of resisting without violence. Secondly, the burglary of a dwelling unarmed under Florida Statute 810.02, subsection 3A. Specifically, there is no probable cause in this case. There is no witness that allegedly saw the defendant here take the bike or even saw the defendant at the property. There is no probable cause for this, based solely on the fact that there's property that may or may not belong to the person who owns the property. There is no witness who indicates that they saw the defendant on the property within the curtilage, or physically taking the bike from that property. Thus, there is no probable cause for burglary as well.
Mr. Peter?
I win cases all the time on those arguments.
I'm sorry, I can't.
I won cases all the time on those arguments, so I don't, there's probable cause, there's arguments to the jury to rely on reasonable doubt. Just because somebody sees somebody breaking into a house doesn't mean that you can't prove that you're not in possession of recently stolen property directly afterwards. Probable cause is a much lower standard than beyond a reasonable doubt. As to if you're trespassing on a construction site or trespassing somewhere else and somebody tries to stop you, they have a lawful duty to do that. If you flee from them, that's disobeying a lawful order. Lowering prowling is always I think the courts have almost basically written that out of the statutes, but that's the only one I wasn't really fought on as far as the PC argument, as far as whether there was PC for that, but everything else, I think there's PC for it.
Your Honor, if I may, the defendant at the time it was flight alone. The defendant at the time stated to law enforcement that he was afraid and just saw the police. That is a common reaction, and based on that flight alone cannot provide probable cause. The only way is if they can prove that the defendant had knowledge of the officer's intent to detain him, and there is no knowledge of his intent to detain him based on the fact that he did not willingly enter property or run from the police for that reason.
Right. Well, as to the burglary, the court finds that the burglary was reported at 1:53 a.m. A bicycle being taken from the curtilage of 1941 Nice Court. The defendant was actually seen at 1:47 a.m. and the victim of the burglary indicated that the burglary occurred about 1:30 a.m. So it was within about 17 minutes that he was in possession of this bike. It's further alleged that he later put down the bicycle and requested that a person ride it for him. I have questions about 2 counts of resisting without on the same arrest, although they're separated somewhat in time and place. The court will release the defendant on his recognizance on the second count of resisting an officer without violence. Bonds will remain as set in the other counts in both cases. Mr. Mohammed, your next court date will be on demand in circuit court. The public defender's office is appointed to represent you. Thank you. Alex Stevens. Good afternoon. State your name, please. Mr. Stevens, you're arrested on charges of aggravated battery, armed burglary, and false imprisonment. Your bond is set at $3,500 on the aggravated battery, $0 on the armed burglary, $3,000 on the false imprisonment. The court Does note the public defender's objection to the no bond on the armed burglary.
Yes, Your Honor. I would like to state, though, for the record, Mary Jane Cooper, on behalf of the Public Defender's Office, based on the fact that this defendant conflicts as a co-defendant with 20 CF 1767 Cartasha Clark that we heard earlier, if the court would be inclined to appoint conflict counsel.
So you're not sure you would have a conflict?
Yes, Your Honor.
That's a fair point. I will find that the Office of the Public Defender has a conflict in representing you, Mr. Stevens, as they represent Ms. Cartasha Stevens Clark in the same incident. I'll appoint the Office of Regional Conflict Counsel to represent you in case 20 CF 1774. Your next court date will be on demand in circuit court, sir. Thank you. Philip Van Clayk. Philip Van Clayk.
Yes, sir, that inmate is in medical.
Okay.
I'm trying to still find out his status.
That's all right. If they bring him here today, we'll address him. If not, we'll call him again tomorrow. The public defender is appointed to represent him. The bonds remain as set at this time. Wayne Brangle. Good afternoon, Mr. Brangle. You were arrested on charges of possession of synthetic narcotics with intent to sell or deliver, possession of more than 10 grams of synthetic narcotic, and possession of drug paraphernalia. Your bonds, I'd set 1,000. For some reason, it says 5,000 on here. Your bonds as to the first two counts involving the synthetic narcotics, setting at $1,000 each, $500 on the possession of drug paraphernalia. The Public Defender's Office is appointed to represent you. Your next court date will be on demand in circuit court. So it's 1,000 on each of this one. All right, thank you, sir. All right, so that's neither the females. We have Sam Shinkman yet?
No, sir, I was told by my supervisor he's on the way.
Okay, do we have anyone that hasn't been called yet?
Yes, we have one female getting her name on. I'm
Okay.
sorry, Your Honor, I try to get these people here as quick as possible. I was thrown in.
That's all right.
This is Espinada Gonzalez.
Okay. Ma'am, if you'll state your name, please. Okay, Ms. Espinal Gonzalez, you arrested on a charge of battery. Oh, you need the interpreter?
Yes, sir.
All right.
Good afternoon, Your Honor. Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has already been sworn in.
Mr. Morales, we're back at initial appearances. We're here on 20 MM 1476, State versus Yohaira Espinal Gonzalez. And, ma'am, if you'll state your name again, please.
Señora, díganos su nombre nuevamente, por favor.
Yajaira Espinal González.
Chajaira Espinal González.
Ms. Espinal Gonzalez, you arrested on a charge of battery.
Señora Espinal González, usted fue arrestada por una acusación de agresión.
Your bond was set at 0.
No,
Ms. Morales, you still with us?
yes, Your Honor. Was the interpreter not heard?
I must have missed it. You told her the bond was set at 0?
Yes, but I'll repeat it again. No se le ha asignado fianza.
All right, do we have, does pretrial release have any prior history on Ms. Espinal Gonzalez?
She has no Florida priors, has history out of Massachusetts in 2005, disturbing the peace and domestic battery. Disposition is unknown, and we were not able to contact the victim today.
All right, Ms. Espinal Gonzalez, I'm going to set bond in your case in the amount of $100.
Señora Espinal González, le voy a asignar una fianza y la fianza es de $100.
The bond will be conditioned upon supervision by pretrial release.
Pero una condición de la fianza es que el Departamento de Libertad Provisional pueda supervisarla.
Until further order of the court, you are not to have contact directly or indirectly with Haim Libier,
Y le está prohibido el contacto, ya sea directa o indirectamente, con Haim Libier hasta nuevo aviso de un tribunal.
You will not return to the residence at 1518 Diamond Loop Drive.
I'm sorry, Honor, was that 1518 Diamond
Correct.
Loop Drive?
Correct.
Le está prohibido regresar a la siguiente residencia, 1518 Diamond Loop Drive.
You may return on one occasion accompanied by a law enforcement officer to pick up clothing or personal possessions you need from that residence.
Sin embargo, puede regresar una vez, pero tiene que estar acompañada de un oficial del orden público para recoger ropa o artículos personales.
The conditions of no contact and no return may be modified by the court.
Las condiciones que se le han impuesto, por ejemplo, que está prohibido el contacto, la prohibición de contacto y prohibición de regreso a ese lugar, es posible que puedan ser modificadas por un juez.
If you want to have contact or return, talk to your lawyer. Your lawyer can arrange for a hearing with the judge that will be handling your case.
Si es que usted quiere tener contacto con esa persona o quiere regresar a esa residencia, entonces tiene que hablar con su abogado y su abogado puede pedirle una audiencia al juez que estará encargado de sus casos.
But until or unless the conditions are modified, you must not return or have contact.
Pero si las condiciones no han sido modificadas, le está prohibido el contacto con esa persona y le está prohibido el regreso a ese lugar.
Your next court date will be
If still in jail, July 2nd. If out, July 20th in courtroom 5B at 9:30 a.m.
Thank you, ma'am.
Las próximas vistas serán el 2 de julio o el 20 de julio, dependiendo si está en la cárcel o no.
Thank you. That's all. Thank you, Ms. Morales.
You're welcome, Your Honor. That was the last one?
We have one more, but I don't think she is. Do we have Ms. Calderon?
No, she's not here yet.
We'll be calling you back, Mr. Morales.
Okay, no problem, Your Honor.
Thank you.
Thank you.
Your Honor, I have Mr. Harrison here and Mr. Van Clark here. Kate.
Okay, John Harrison. State your name, please.
John Robert Harrison.
Mr. Harrison, you arrested on charges of petty theft and possession of drug paraphernalia. You have a bond of $500 on each of those two counts. It appears you were also out on probation in Orange County Case 17 CF 1626 on a charge of grand theft. Been arrested for violating that probation by allegedly committing the new crimes with which you're charged. Your bond on the Orange County case is set at $0. The Public Defender's Office is appointed to represent you in all your cases at this time. You may be able to resolve all your cases while you're here in the Osceola County Jail. You can talk to your attorney about that possibility. Your next court date will be
Next court date is still in jail, July 2nd. If out, July 20th in courtroom 4E at 9:30 a.m.
Thank you. Yeah, we reset him. No, we'd already reset him, but since he's here, we'll address him.
Did we?
Right.
Edward Dacius.
Who have we got now?
We have, Your Honor, Dacius Edwards.
All right. Good afternoon. Tell us your name, please.
Edward Dacius.
Mr. Dacius, you're arrested for violation of an injunction by returning to within 500 feet or remaining within 500 feet of a residence after having been served with an injunction. Your bond was set at zero. What kind of information do we have on Mr. Dacius?
We have criminal history going back to 2006, charges of domestic battery, most recently, February 2019, resisting without violence, assault on Leo, possession of controlled substance and drug paraphernalia. He was adjudicated withheld on those cases, and we were not able to contact the victim today.
Well, I think he's entitled to a bond being set. Mr.
Your Honor.
Give him 500 with PTO.
Mr. Dacius, where do you stay when you're not in jail?
At another side of the street. That day, my mom called me over, and then she wanted me to see me, and then.
Well, don't talk about the facts of your case at this time. I'm
Yeah,
just,
I don't know over there.
where do you usually stay, though?
I usually stay on the streets, but nowhere.
Nowhere?
Yeah, I'm not in the house no more.
So if you get out of jail, where would you go?
Not back to her place.
I'm sorry? Not back to her place, but do you have another place you can go?
Yes.
Like where?
Going to a friend's house.
Your Honor, Mary Jane Cooper from the Public Defender's Office. I just saw in the arrest affidavit, I did see that it was indicated that there was a mental episode. I didn't know if the defendant qualified for mental health PTR.
He might. I don't think he qualifies for,
He will have to have a bond, Judge.
sorry?
He will have to have a bond
Yeah.
with the PTR or mental health.
That's
condition.
That's
$100, 500 PTR.
Okay.
It looks like mental health pretrial release might be appropriate, though. All right. Mr. Dacius, I'm going to set bond in the amount of $100.
Your Honor,
It'll be, I'm sorry?
may I say something?
Yes, sir?
I have no contact with my mom, so she's the only one that can bond me out, so, you know.
Well, you now have a lawyer, so your lawyer can talk to you and maybe help put you in contact with someone else who might be able to help you bond out. I cannot release you without a bond. $100 is as low as really I can go. It will be conditioned upon supervision by pretrial release with mental health conditions or mental health pretrial release if he qualifies. It will be conditioned that with Mr. Dacius not having any contact with Madeleine Louise June and not returning to the area of 1809 Cornet Place or going within 500 feet of that residence. Mr. Dacius, the Office of the Public Defender is appointed to represent you. If you're still in jail, someone from that office will be in touch with you very shortly. If you get out of jail, you need to contact that office immediately so they can start working to help you.
Your Honor, can I say something?
All right, your next court date will be,
Is still in jail July 2nd. It filed July 20th in courtroom 5B at 10:30 a.m.
pretrial release will have those dates and times for you.
Your Honor, I can't even use the phone where I'm at in jail.
If he is in a self-harm area, they do not allow them to use the phone. Your Honor, I would like to ask if it's possible at all to release him on ROR. I realize that that would be not the preferred way.
More information before I be,
Well, I was going to ask PTR if there is any evidence that he's failed to appear in the past.
I'm not concerned about failure to appear. I'm concerned about the reason for the injunction and the potential harm to the person who was the petitioner in the injunction, so you'll have to schedule a hearing if you want
Okay.
She called me
More
over
than
to
that.
her place. And I'm getting,
Thank you, sir.
I don't understand, bro, why I'm here. You don't know my life, dude. You don't, man.
Thank you. So who do we have now?
Yes, Your Honor, we have Mr. Van Clay. and he's
Okay,
a little
Philip
hard
Van
of hearing.
I'm sorry?
He's a little hard of hearing, he was telling me.
All right. Hello, please tell us your name. What is your name, sir? Mr. Clake, you arrested on 2 charges of trespass. You have a bond in each case of $500. The Public Defender's Office is appointed to represent you.
You do qualify for direct PTR if you wish to release him now.
Okay. Mr. Van Clake, where, do you have a place to stay if you get out of jail? Do you have a place to stay if you are released?
In the woods.
Okay. All right, I'm going to release you on pretrial release in these cases, but you have to stay away from the Wawa store at 2184 East Earlo Bronson Highway. Can you stay away from Wawa?
Sure.
They don't want you there for some reason. Okay. Your next court date will be,
Next court date for 2020, MM 1483 and 1484. If still in jail, July 2nd. If filed, July 27th in courtroom 4A at 10 a.m.
you probably didn't hear that. Pretrial release will give them the dates, court dates.
Thank you, sir.
Thank you.
I have your final interpreter, Calderon, Ms. Taylor.
Okay. All right.
I do have a probable cause argument, Your Honor.
Good afternoon, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has already been sworn, Your Honor.
All right, good afternoon, Mr. Leal. We're here for initial appearances, and the case we're going to be addressing is 20 CF 1766, State versus Nakina Calderon. She does not have the headset on. Please tell us your name.
Díganos su nombre, por favor.
Latina Calderon.
Nakina Derón.
Ms. Calderon, you were arrested on charges of aggravated battery and resisting an officer without violence.
Señora, usted se le acusa de agresión agravada y de oponer resistencia sin violencia.
Your bond is presently 0 on the aggravated battery charge and $500 on the resisting charge.
Se le dio fianza por resistirse $500, pero no se le concedió fianza por la amenaza agravada.
The Public Defender's Office is appointed to represent you.
La Oficina de Defensoría Pública ha sido designada para representarla legalmente.
Your attorney is going to make an argument to the court as to the probable cause to believe you committed at least one of these charges, so you may proceed.
Thank you, Your Honor.
Así que se dará un argumento que va a ser presentado por la abogada.
Your Honor, Mary Jane Cooper from the Public Defender's Office, and the probable cause argument is on the aggravated battery under Florida Statute 780.
Let me cut you short on that. State, do you wish to be heard?
No, Judge.
Okay, I agree with you. I find probable cause for battery only.
Entiendo que hay indicio de culpa nada más por la agresión física, nada más.
Does Ms. Calderon have any prior history?
¿Ella tiene antecedentes, la señora Calderón?
Judge, we found 2 open cases here in Orange County, citations for no vehicle registration and no tags. Also history out of the state of Texas. 2008 assault on a public servant. She was found guilty. Possession of marijuana under 20 grams. She was found also guilty. That is all.
Sí, tiene un historial tanto de Texas por un ataque a un empleado público y otros aquí también locales por no tener matrícula y por no tener placa. Esos son 2 casos que tiene citaciones.
Ms. Calderon, I'm going to set bond in the amount of $500 on the battery charge.
Señor Calderón, entonces sí le voy a dar fianza para que salga bajo fianza de $500 por el cargo de agresión física.
It will remain at $500 on the resisting charge.
Para los $500 por haber opuesto resistencia.
The bond will be conditioned upon you not having contact with Jose Antonio Rivera Torres
Y claro, se le prohíbe el contacto con José Antonio Rivera Torres
until further order of the court.
hasta nuevo aviso de la Corte.
It is also conditioned upon you not returning to 259 Magellan Drive in Kissimmee
También que no vuelva a 259 Magellan Drive en Kissimmee
again until further order of the court.
hasta nueva orden de la Corte.
You are not to possess any weapons or firearms of any kind.
Se le prohíbe la tenencia de cualquier tipo de arma, incluyendo armas de fuego.
Your next court date will be on demand in circuit court.
Y la próxima fecha de comparecencia será cuando se le notifique en el Tribunal del Circuito.
The court is not going to take any action on the Orange County traffic cases.
Your
Y
Honor,
la Corte no va a tomar en cuenta los casos en Orange County.
with regard to the no return, I see that she has two minor children that are only her children, and I do not see that the two parties reside together. So I guess the question is, I'm not in the court to ask her, is 259 Magellan Drive her property, and does he reside at that property?
En cuanto a la orden de no volver, ella tiene niños menores que los niños son solamente de ella, y ellos no viven juntos en la misma residencia. Entonces quería saber si esa 259 Magellan Drive, esa es la propiedad, es de ella, porque yo no estoy ahí en la corte para poder preguntarle a ella directamente.
It says that
I do see that it says he was packing a suitcase.
it refers to the children as their two children
Se refiere a los dos niños
and to Mr. Rivera Torres as her husband.
Aquí dice que Rivera Torres es el esposo.
I think the children are presently with,
Yeah, I'm sorry, he's the father of my two babies too.
I think the children are with Corrales Delgado Munoz.
Los niños están con Corrales Delgado Núñez.
Yes, sir. Yes, sir.
So I think she'll need to address that with her.
Okay.
Thank you, Ms. Calderon. If you get out of jail, you need to immediately contact the Office of the Public Defender.
Pero cuando usted salga de la cárcel, si sale, tiene que inmediatamente ponerse en contacto con el defensor público.
If you remain in jail, a lawyer from that office will be in touch with you.
Y si usted permanece en la cárcel, pues un abogado de la Defensoría Pública tendrá que contactarle a usted.
Thank you.
Gracias.
Thank you.
Do we announce the next court dates? Oh, yeah, it's on, yeah. Okay, do you know if we're going to be able to get Mr. Shinkman or Mr. Stringer this afternoon?
Mr. Stringer is present. Mr. Shinkman. Mr. Stringer's there. I'm sorry, Your Honor.
That's all right.
It's a cluster here today. Mr. Stringer is present. Come up, sir. Mr. Shinkman, due to medical reasons, he won't be present today, Your Honor.
All right, so as to Mr. Shinkman, we will reset him to tomorrow. Hopefully he'll be able to join us. I'll leave the bonds as set at this time. And fine, PC. State your name.
Brad Stringer.
Mr. Stringer, you arrested on a warrant for violation of probation in case 19 CF 3136. On possession of cocaine and possession of drug paraphernalia charges. Your bond is set at zero. It's going to remain at zero. The Public Defender's Office is appointed to represent you, sir. Your next court date will be,
Next court date, June 29th, in courtroom 5F at 8:15 a.m.
thank you, sir. So I think that's all we have then?
Yes, sir. Mr. Chowders, he bonded.
Okay,
That was the only one we didn't address.
very good. Thank you.
Okay, thank you, Your Honor.
Your Honor, Mr. Shinkman is the one that's in medical, correct? That's being reset? Is he PD appointed or?
Yes.
Okay. Thank you.
Thank you. So we'll take about something sign stuff and take a quick break, and then we'll come back and what we got.
Judge, I talk you into swearing me in so I can mail this thing off.
I'm sorry?
I talk you into swearing me in so I can mail this off.
Yeah, sure. Absolutely. When do you,
July 6th is gonna be my.
yeah, we're proud to do that. Yeah, come on. All right, Mr. Urbane, if you'll repeat after me. I do solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States and of the state of Florida, that I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of County Court Judge for Orange County. On which I'm now about to enter. So help me God.